Original site, commercial division. To mention item number 1, Kotak Mahindra Bank Limited versus Krishna Kumar Jadhav and another.
Lordship, this is my execution.
Screen. Yes.
Lordship, this is my execution application. The matter has been settled between the parties. I wish to withdraw the application.
But did the other side ever appear in this?
No, Lordship.
No.
No. There was a direction under Order 21, Rule 22. Firstly, which could not be served. We got an alternative address, which was directed to the
Outside, based outside Kolkata?
Yes, Lordship.
The advocate on record of the petitioner submits that the matter has been settled between the parties and seeks to withdraw the execution case. Stop. EC 291 of 2022 is accordingly dismissed as withdrawn. Interim orders, if any, shall stand vacated. Any warrants of arrest?
No, Lordship.
Item number 2, Mohit Mall.
I will dictate the order at 11:30. All right. Is that all right with you, both of you? You don't have to be here. I'll dictate it.
Lord, may I have the liberty to file my wakalatnama?
Yes, of course. Do it. At 11:15, actually, not 11:30, 11:15.
Wait for me.
Item number 3, GHSPL MLD Super Specialty.
Well, this is my application, section 11 application, madam. Well, before I start, madam, may I indicate that service
Your-
is not complete.
Not complete.
No.
Then you can't start. Learned counsel appearing for the petitioner submits that service is yet to be completed. When will you?
Well, in the track report yesterday, I've seen that it is showing insufficient address, but this is the address in the agreement, as well as we have sent letters to that address. They have replied from that address only. So, my lord, another 1 week, my lord, so that we can again try.
Yes, this is
serve
matter after a week as paid for.
that. Oblige, my lord.
Item number 4, KOS Industries.
So this is my application. Lord, I was supposed to come back on the sheet chart.
Yes, yes.
Lord, there's nothing wrong with the chart.
Yes.
My lord, I've handed up the charge. May I explain, my lord, what calculation have come to, my lord? Will allow me 2 minutes.
So that Mr. Chaudhary can wake up to his some new rights which he will discover.
Rights are closed.
I will.
Arguments are.
Very well, you can explain it. 2 minutes.
My lord, on the first page, my lord, this is, my lord,
Microphone, please, Mr. Mukhopadhyay.
my lord, on the first page, my lord, this is, my lord, the chart indicating, my lord, the number of goods supplied, the date of supply, and the date of return of the number of goods that were returned. 600 were withheld. So, my lord, we
No,
see on
first page, which one are you?
first page, AP 70, my lord.
Yes, sorry, yes.
First page, my lord, we'll see duration of use of goods. Therefore, my lord, on the left-hand my lord, the 2 left-hand columns, my lord,
Yes.
is the number of goods supplied. This is all as per the affidavit. The date of supply, my lord. My lord, the footnotes indicate the page numbers of the affidavit are already placed on the last occasion. On my lord, the 2 right-hand columns, my lord, are the number of goods that were returned. 900 plus 500, 1400 were returned. 600 were withheld. So 2000 admittedly supplied, 1400 returned, 600 withheld. Dates of
Yes.
supply. My lord, for simplicity's sake, I've taken October 2019 as the date of completion of all supply. To simplify the matter, my lord, on the next page, my lord, I've given a calculation of the admitted rate, admitted rental calculation. So that will be the number of goods, my lord, with the number of months multiplied with the number with the admitted rate multiplied. The rate also I've provided in the footnote.
So why are there, all that I have to see is what
My lord, that
amount
is the total figure,
the
22.
600 units
Or-
will fetch?
My lord, the 600 are the third and fourth rows, my lord. That is the 600. But my lord, I have claimed the entire amount. I've broken it up in case, my lord, it commences.
And what is this payment received? So
payment
Mr.
received? This is the amount
already this
admitted.
is, you have received this
I've
one.
received this amount.
So now
I
you
have
get
given-
22.29 lakhs.
Yes, yes. As per my calculation, as per their affidavit, this is, my lord, without GST, my lord, without interest as per the MSME Act. I'm an MSME unit, my lord. I have not claimed anything. for the security, for the purpose of security. The rest I will prove in the arbitration. This is the amount as per my calculation, as per their affidavit, I am entitled to as on date.
And what is this 36-2?
26(2), my lord.
No, what is the application I'm hearing? AP
Well,
70?
70 is a section 9 application.
Section 9.
Section 9
Do you
during
want the security in that section?
security for this entire amount. This is admitted as per their own affidavit. None of
Reference.
my lord, during technically, but my lord, the first sitting has not been held as yet. This is under the MSME Act, my lord. I'm a supplier. I had approached, my lord, the conciliation process ended in January 2023. Immediately thereafter, I filed this application. So technically during, my lord, the division bench had also.
Conciliation process. Then what about the, so arbitration has not started?
No, it has started in January. The conciliation terminated in January and therefore
So
arbitration.
you haven't reached 18-3 stage as yet?
18.3, since the conciliation has terminated, I am in 18.3 right now, but the first meeting still hasn't been convened of the arbitral tribunal. I've submitted my statement of claim, all that is done.
Yes. This is an application filed by a supplier for interim relief under section 9 of the 1996 Act. Stop. The supplier, the petitioner claims to have supplied. What goods are these?
My lord, these are in the nature of MS props, they're construction material effectively, MS props specialized.
Yes, supplied construction material to the respondent, comma, more specifically, construction material, comma, more specifically MS props, MS একটা কথা, props আর একটা কথা, capitals, to the respondent, MS props, comma, to the respondent for a duration of about 9 months. Is that correct?
Approximately, my lord, 8 months for the 1400 return. And,
Yes, for a duration of approximately 9 months. Stop. There is no dispute that the respondent received the goods and in fact returned some of the goods. Stop. Some of the goods to the petitioner. Stop. The next, the dispute now is on the admitted 600 numbers, units of goods retained / withheld by the respondent for which the petitioner claims security. Stop. It is also admitted that the respondent did not raise any complaint with regard to the goods, and the point of the alleged short supply, short-supply, may be, is disputed on behalf of the petitioner. Stop. Next, the affidavit in opposition states, unequivocally states that affidavit in opposition, unequivocally states that the respondent is entitled to withhold 600 pieces of MS props, page 32, MS props, for the petitioner failing to return the security checks to the respondent. Stop. Since this is the stated position in the respondent's ' affidavit in opposition, comma, the court requested learned counsel appearing for the parties to hand up tabulations of the rent due for those 600 goods at the agreed rate between the parties, semicolon, the agreement is of 29th August 2019. Stop.
Well, there are 4 purchase orders. Purchase orders
Uh,
of
uh, the,
29.
the agreements, there are 4 purchase orders which constitute the agreement. Stop. Next. The next, learned counsel appearing for the respondent is gracious enough. Some other word, not gracious.
No, we don't admit it, but
Is
calculation
fair enough, FAIR, fair enough to say that the respondent has indeed held on to the 600 units. Stop. And that the calculation of admitted rent due from the respondent may not be disputed at this stage.
one. Now, if your lordship, instead of saying calculation of admitted rent, the mathematical calculation I'm admitting, but we don't accept
Yes,
anything else.
ki bola? And that the mathematical calculation arrived at is not disputed, at least at this stage. Stop. Next. The chart shows that the petitioner supplied a total of 2,000 units to the respondent by October 2019, of which 600 units were and continue to be withheld by the respondent. Stop. The rent for the balance 600 units from July 2020 - July 2023 within brackets 36 months, close bracket, comes to rupees 17,28,000 /. Stop. The petitioner has already received rupees 4,90,880 / from the respondent, and hence the amount due as on date is rupees 22,29,120 /. Stop. Next. The respondent shall hence secure the amount of 22,29,120 /. How will you do that, Mr. Chaudhary?
To be, my lord, absolutely candid, my lord, I have instructions. My lord, the mathematics, my lord, we have accepted, but otherwise, my lord, we, my lord, don't accept it, my lord.
No, that's all right. But how will you, since it's an order of court, how will you
Yes.
secure this amount?
The lordship, my lord, directs whichever way, my lord, the lordship feels, my lord.
Yes, what is
Because
the
I
good way?
have instructions to, my lord, we
Yes,
have
yes, of
it
course.
tested.
Cash, my lord, will be kept with the register of this court, my lord. In a fixed deposit.
Yes, the respondent will secure this amount, jeta bollam, by way of a cash deposit to be kept with the registrar, original side within 3 weeks from today. Stop. The registrar will invest this amount in an interest-bearing account with a reputed bank, which is a constituent of the Reserve Bank of India. Stop. What remains of the 9?
My lord,
Section
the
9?
injunction, my lord, I'm enjoying an ad interim injunction. My lord, will confirm that in respect of the 600 goods.
What is that injunction?
My lord, 2nd March 2023, the order should be, my lord, of the division bench. My lord, that is APOT 63.
Yes.
63. My lord.
Yes, there is the ad interim order of injunction passed by the division bench in favor of the petitioner on 2nd March 2023, restraining the respondent from alienating or disposing of the material lying with the respondent for a period of 3 months from the date of the order is confirmed. Stop. And do you want to continue with the 9, or what do you
My
want?
lord, it can be disposed of, my lord. My lord, only one indulgence, my lord. I'd refer to 2 case law, my lord. Rahul Shah, my lord, will refer to that if it commences to, my lord.
Case গুলো এখানে আছে নাকি দাদা?
Rahul Shah and, my lord, that Bombay High Court. In
On
support
the
of my
38.5,
on my 38.5, correct. Point of security.
yes, the court has also considered, in passing this order, the court has also considered the Supreme Court decision in Rahul S. Shah versus Jirendra Kumar Gandhi, 2021 6 SCC 418, and single bench judgment of the Bombay High Court in JP Parekh versus Nasim Qureshi, delivered on 8th December 2022. No, in commercial arbitration petition numbered 629 of 2021, delivered to Kirada. On the issue of the requirement of a defendant in an action for payment of money to require, to disclose his assets on oath, and the power of the court to demand security to ensure satisfaction of any decree in appropriate circumstances. AP 70 of 2023 is accordingly disposed of in terms of the above. Since affidavits have not been called for, the allegations in
My
the
lord, this is
application.
after affidavit, my lord.
This after
They-
affidavit?
Affidavit in
Get it
opposition.
out, get it. Yes, yes, of course.
Grateful.
Five KOSC.
My lord, this is a similar application to, my lord, here there are no express my lord, admissions in the affidavit in opposition. However, my lord, the division bench has noted an admission in an email issued by the respondent in respect of some goods that are still being withheld by them. And on the basis of that, I had been granted a similar order of injunction. My lord, this is my basis. I had also given up handed up a chart, my lord, for balance goods.
Where is
lying.
the admission?
My lord, will kindly take. My lord, may I place the order of the division bench first, my lord,
Yes.
and then I'll. My lord, may I hand?
Aki, okay.
Similar
Good, good, good.
transaction, my lord.
Yes.
My lord, this is a different, since this is a different matter, my lord,
Different, no, order is
Order.
different.
slightly different, my lord.
Very
since the
well,
facts are
yes.
Slightly different. POT 64.
This is the one, yeah, very well, yes. What do you want to show?
My lord, page 2, my lord, will kindly come to.
Yes.
Third line from the top. My lord, however, the email dated July 14, 2020 would further reveal that the respondent has taken responsibility of the shortage at the Noihati site. The shortage was disclosed.
Respondent is you.
The respondent is them. The shortage was disclosed to the respondent on July 14, 2020 in relation to the Howrah fire station as well as the Noihati site. We are only concerned with the Noihati site. My lord, will then come to the 12th line from the top.
Oh, so respondent before the division bench is Mr.
It-
Chaudhary's client?
Yes,
Very good,
yes.
yes,
I had filed an appeal.
yes.
My lord, towards the middle of that same page, my lord, there is a categorical, my lord, page 2.
Yes.
The sentence starting with there is a categorical stand of the respondent that the shortage in relation to the Noihati site is a responsibility of the respondent, and therefore we do not think that there is any specific dispute having raised in relation to the disclosure made in the email dated 14 July issued by the petitioner. Therefore, my lord, may I refer, my lord, to this, these two emails. That is where the admission is. This is noted by the division bench and I'm granted an
No,
order of
both are
injunction.
14 July 2020.
Yes, on the same day, my lord, trailing mail.
Yes.
I had issued an email setting out, my lord, the shortage, short material. They had replied stating that they take responsibility for the short quantity. On the basis of this, that order of injunction was passed. May I
Yes.
take, my lord, to that email, my lord?
So this is not there are no affidavits.
There
there.
is an affidavit. They haven't categorically, like in
Yes,
8070,
yes,
there
that's
is no
fine.
category.
Yes.
My lord, I have also indicated these pages in my chart. I had also handed over a chart for this matter as well.
Is the amount different?
Amount will be different. My lord, amount will be less. It will be a total security I'm claiming on the basis of their admission
Yes.
is 3.71 lakhs.
Yes.
My lord, will kindly take page 185 to 186 of the affidavit in opposition.
Not 3 point. You have said 1.69
No,
lakhs.
that is for the goods withheld, and on top, my lord will see that's the total outstanding sum for the goods returned. They returned some goods similar to that matter. They returned some goods, withheld some. This tabulation is the goods that were withheld as per the purchase order. I've
Yes.
calculated 3.71 is the total that I'm claiming after adjusting the amount that they've paid. 80,000 they had paid.
Yes. So 1.69 plus which
Plus,
amount?
plus, my lord, on top, the first line on top, 2.02. 2.02
Yes,
plus
yes.
1.69.
Yes.
My lord, may I take, my lord, to that email, volume 2 of the affidavit in opposition. My lord, 185
Yes.
and 186.
Who is this Lakhotia?
Lakhotia is, my lord, the respondent before, my lord.
Yes.
And my lord, KOAC is my client.
Yes.
My lord, will see the email starting, my lord, by my client towards the middle of the page, 14 July 2020. This is the prior in time email, 1:14 PM. My lord,
Yes.
will see a table. My lord, will see first, after the, my lord, description, fire station, my lord, we are not concerned with. My lord, we'll ignore that. The second row is Noihati. My lord, will see those tabulated figures. That's the same I've indicated in my chart. Will
Yes.
turn over to 186 as well. These are the balance quantity that is being withheld by them. And my lord, their reply is at 185 on top.
Yes.
That is, my lord, being issued by God of Lakhotia. That is their director, my lord. My lord, will see the last sentence of the first paragraph. Further material shortage in Noihati site, we take the responsibility of the same.
Yes. But where do I get the 600?
My lord, there is no 600 here. Here, my lord, the tabulation that I've provided is admitted. And that is on the basis of that I've provided my chart.
Yes.
Here, my lord, not MS props. These are different material, my lord. These are other construction material, but not MS props. My lord, so therefore, on the basis of this admission, the division bench, my lord, had granted me an order of injunction. On the basis of this admission, my lord, I rely upon,
Very
I had calculated.
Mr.
the chart.
Chaudhary, what do you have to say?
My lord, I have, my lord, two things to say.
Yes.
If your lordship, my lord, is, if I argue on merits, that will, my
Yes.
lord, create a, improper situation. Because my defense is the same as in the first matter. If your lordship feels that in this matter, the admission is not adequate, or your lordship, and there's a different basis for your lordship's order, I would request your lordship, my lord, to keep it after 2 weeks.
Why? Why 2 weeks?
My lord, we will, my lord, we will not accept the first order, my lord. We'll try our luck, my lord, and have it tested. But I can't, my lord, do something which will have the result of even there being a possibility of 2 contradictory orders, because my defense in the second matter is the same as in the first matter. So, my lord,
So how does it matter then if I pass an order?
no, it doesn't. It
Yes.
doesn't, my lord. But if I am to argue on merits and try to persuade your lordship to give a different
Very well, I will
finding.
not dispose this off. I will pass the order and keep it pending.
No, my lord, your lordship can dispose it of. Your lordship, my lord, I would, my lord, request your lordship not to, my lord, hold on merits in my favor, because that would be a
No,
contradiction.
the last one also I did not hold on merits.
Yes.
It was
so-
on the admitted case as made out in your affidavit in opposition.
Yes, yes. So this also, my lord, there is an.
And you try your luck with regard to both orders.
Yes.
Why only one?
Yes. No,
Both orders.
I can't today now, after losing the first matter, argue the second matter and request that.
So I'm
please hold
passing an order in the second matter. You try your luck in both.
Yes, yes, yes.
The petitioner before the court is a supplier who supplied certain construction material to the respondent over a period of time, approximately how many months?
But here about approximately
Approximately 8 months.
8 months, my lord. After that, 40 months they've been withholding. After that-
Stop. The petitioner seeks interim orders for interim orders in the form of a direction on the respondent to provide security for the units which are admittedly withheld by the respondent. Stop. The admission would be apparent from mails exchanged between the parties on 14 July 2020, semicolon, the first by the petitioner, containing a chart of the amount pending from the respondent from the Noihati, Nolhati or Noihati,
Noihati, only Noihati side. my lord.
from Noihati, on account of the material retained by the respondent. Stop. The reply of the respondent on the same day states that admits to the outstanding rent and with a request to the petitioner to send a revised reasonable fair rate in order to resolve the matter. Stop. The respondent's mail also refers to short supply of material from the Howrah fire station site.
Might not be relevant for the purpose.
Wait,
of this.
also refer,
Only
Kirada,
the
also
last
refers to Kirada. This, next, the exchange of the correspondence between the parties and the admission made by the respondent in the mail was noted by a division, by the division bench in its order dated 2nd March 2023 in an appeal filed by the petitioner, where the division bench records the categorical stand of the respondent that the short supply of material is the respondent's responsibility. Stop. The division bench proceeded to pass an order restraining the respondent from transferring or alienating or creating any third-party interest in respect of the material lying at the Noihati site, disclosed by the petitioner in its email of 14 July 2020 for a period of 3 months from the date of the order. Stop. 3 months have gone.
Well, after that, it was extended. I still have.
The interim order was subsequently extended by the division bench.
By this, on,
Kirada, the division bench subsequently extended the interim order
my lord, this honorable court. my lord.
on 11th May 2023. Stop. Next. The admitted facts are as follows. Stop. The respondent supplied all the agreed goods by 13 July 2029 without any complaint of defect, without any complaint raised by the respondent on the quality of the material supplied. Stop. Some of the goods were returned by the respondent on 22nd February 2020. Stop. The calculation of the admitted rent due from the respondent as per the purchase order and the fact that the respondent used all the goods from July 2019 - February 2020 is also without dispute. Stop. The outstanding principal sum of rent for July 2019 to February 2020, that is unpaid rent from the respondent, comes to rupees 2,02,376.00. Stop. The amount of goods withheld as per the chart disclosed in the mail of disclosed in the mail of 14 July 2020 translates to rupees 1,69,480.00. Stop. The total principal amount due from the respondent to the petitioner as on date, adding these two amounts would come to rupees 3,71,856.00. Stop. Have you shared the chart with Mr. Chaudhary?
My lord, just one thing.
Next, the calculation in the chart prepared by the petitioner has been shared with learned counsel appearing for the respondent. Stop. Yes.
My lord, the total unpaid rent is at the second page, first line, my lord, not 22, because I have given them credit for this 80,000 they've paid. It's 2,02,376. This is the unpaid rent for the total amount.
That's what I've said. Check the order. Jeta bola na unpaid rent due from this respondent is 2,02,376.00. Figure gulo taken. Next, the respondent shall hence secure the amount of rupees 3,71,856.00 by way of a cash deposit with the registrar, original side of this court within 3 weeks from date. Stop. The একই জিনিসটা বলে দাও আগের বার যেটা order এ বলেছি। Next, last ওই লাইনটা Rahul S. Shah and Bombay High Court ওটাও থাকবে। ঠিক আছে? AP 71 of 2023 is accordingly disposed of in terms of the above.
Deeply appreciate, my lord.
Grateful.
Item number 6, Stray Equipment Finance.
Please, Your Lordship.
That I had finished my submissions, Your Lordship.
What was the point, Mr.
My
Shah?
lord, here, my lord, there was mortgage of, my lord, certain flats,
Yes,
13
yes.
flats, my lord.
And Mr. Thakur is saying that's not an arbitrable.
Yes, my lord, for that, my lord, he relied on Booz Allen. My lord, Booz Allen, my lord, is very categorical. It says only in respect of mortgage suits. That is suits for, my lord, enforcement or foreclosure of mortgage. My lord, I just want to show you, Lordship, my lord, one paragraph of the judgment in this regard. I think, my lord, that should take care of this point. But may I hand up? Booz
No,
Allen?
so Mr. Thakkar's point was that it cannot be a claim which is arbitrable
That's right.
and therefore cannot be, what is it? It's a section 9? What is
This
it?
is a section 9. Madam.
Section 9.
Section
yes.
9.
My lord, my submission before your lordship was that, my lord, here, my lord, I'm not seeking to foreclose mortgage. I'm seeking to recover money. My dispute is with regard to money, my lord, remaining unpaid. I have, my lord, said incidentally that there are several securities that were created for repayment of money. One of them being the mortgage, my lord, flats. And my lord, I've shown your lordship an instance where at least one flat has been dealt with. And my lord, that has, my lord, led to proceedings, my lord, under RERA. My lord, there have been, my lord, contempt applications filed. There's attachment orders.
Claims made on the respondent.
That's right. Well, if you look at
Those are what? Statutory claims?
a statute, I don't think it's a statutory claim. My lord, these are claims made on account of, my lord, perhaps delay in delivery of possession or, my lord, overcharging of, my lord, for the
Fair.
flats, etc. Well, we are not really aware of exactly what is the complaint. Well, if your lordship kindly see, my lord, Booz Allen, I'm told that your lordship
yes,
has a
I have
copy.
Yes.
Well,
Mr.
paragraph 46. An agreement to sell or an agreement to mortgage does not involve any transfer of right in rem, but creates only a personal obligation. Therefore, if specific performance is sought, either in regard to an agreement to sell or an agreement to mortgage, the claim for specific performance will be arbitrable. On the other hand, a mortgage is a transfer of a right in rem. A mortgage suit for sale of the mortgage property is an action in rem for enforcement of a right in rem. A suit on mortgage is not a mere suit for money. a suit for enforcement of a mortgage being for enforcement of a right in rem will have to be decided by the courts of law and not by arbitral tribunal. So it's a suit for enforcement of a mortgage. Well, that is that. I don't think I need to trouble your lordship with other paragraphs. Well, he had next said that there are orders passed by the Bombay High Court restraining sale of all the flats that remain unsold in the property.
Yes.
After being served with a copy of that order, we have made inquiries. It appears that these orders have been passed in a contempt application. Of course, we are not exactly privy to what
Sale
has
of
happened.
flats
Yes.
in a contempt application.
Yes, apparently, there was some violation of some order passed, by probably, the RERA tribunal. And in that an order was passed. But, we have since, proceeded to file a writ before the Bombay High Court saying that, these are our securities over which these attachment orders could not have been levied. But, that's neither here nor there because, tomorrow, if the attachment order is lifted for any reason, considering, their conduct, they will go and sell the flats once again. So, this order of injunction is presently what I will seek from your lordship. I have also made a prayer for receiver. But, since there is already a subsisting, order from the Bombay High Court, that, prayer I shall, pursue before your lordship, once, I obtain some clarity with regard to the proceedings in Bombay. But for now,
No, what clarity that they Bombay High Court couldn't have given that direction?
yes, because these are ultimately, I say, my
securities.
securities. So, I have not seen the copy of the writ petition filed with the Bombay High Court. I have just been instructed that
That's all.
we filed a writ petition. But I only now, for the present, ask for an order of injunction, in terms of prayer A.
Not to alienate those 13
That's right.
flats.
That's right.
Yes. Car parking space, yes.
Yes, well, it's 13 flats and 66 car parking spaces.
Very well, yes.
Well, Mr. Thakkar wanted some time to make some submissions on this, but
Yes,
this is all
yes.
that.
Yes, I think some time was taken on his account.
Yes.
Please.
Yes.
But I just have this preliminary objection on maintainability. I'll take other defenses once your lordship permits me to use an affidavit. My preliminary objection, which Mr. Saha has addressed, is that this reliefs relating to mortgage of properties and no claims arising out of a mortgage of a property is arbitrable. That is squarely held in Booz Allen. May I just show your lordship, paragraph 42, please, of Booz Allen. It is not the issue in Booz, the fact situation in Booz Allen was, a mortgage suit was filed in the original side of the Bombay High Court. Suit filed by State Bank of India seeking to enforce its mortgage.
Yes.
Now, the loan document had an arbitration clause and a Section 8 application came to be filed. The Section 8 application was rejected on the ground that the mortgage suit it cannot be stayed and referred to arbitration. From that, this appeal came to the Honorable Supreme Court. Now, the issue before the Supreme Court was whether the enforcement of mortgage could have been directed by the tribunal. If it could have been directed, the matter could have been referred to arbitration. In that context, this judgment came to be made. Kindly see paragraph 42, please, Malad.
Yes. Yes.
The distinction between disputes which are capable of being decided by arbitration and those which are not is brought about in 3 decisions of this court. I'm not troubling your lordship with this decision. That is first decision on winding up. Then the other decisions are there. Now, kindly turn over to paragraph 46, which Mr. Shah says. The issue is this, whether this dispute can be decided by a tribunal. And the paragraph 46, I rely on the same sentence which Mr. Shah placed. On the other hand, a mortgage is a transfer of a right in rem. A mortgage suit for sale of the mortgage property is an action in rem for enforcement of a right in rem. A suit on mortgage is not a mere suit for money. A suit for enforcement of a mortgage, being the enforcement of a right in rem, will have to be decided by the courts of law and not by the tribunal. So, any relief arising out of a document of mortgage, a mortgage agreement, has to be decided by a court of law and not by an arbitral tribunal. Now, if the tribunal is not competent to...
Mr. Thakkar, sorry to interrupt. What is Mr. Shah's client wanting in this case?
My lord, in this case, he wants to enforce his right on security. I just beseech your lordship to take 3 paragraphs of his petition as they are, my lord, without making any additions to what has been pleaded. Kindly come to paragraph 28, please, my lord. At page 12. He seeks to enforce his security right and protect his security interest. Now, kindly see paragraph 28
Yes,
at the bottom of page 12.
yes.
However, considering the urgency in the matter and in specific view of the fact that the respondent has continuously and deliberately intended to decrease and or dissipate the security interest or assets of the petitioner, interim measures are required to be provided for in favor of the petitioner, as mentioned here and above, interim measures, etc. So, my lord, it is the security interest or asset of the petitioner which is sought to be secured. Then, my lords, kindly see paragraph 29, please, at the same page, bottom of page 13.
Yes,
May I place the entire paragraph? There is every likelihood that the petitioner would lose the security interest over the assets of the petitioner as the petitioner came to learn that the respondent is adversely indebted to several other creditors and unable to pay its debts. There's every apprehension that the respondent may adopt ways to render the security interest of the petitioner as nugatory. And kindly see, we can omit two sentences in the last sentence of this paragraph. The respondent has invaded or threatened to invade the lawful rights of the petitioner to enforce its security interest in respect of the assets. So, my lord, all the interim protection which is sought for is in respect of the security interest of the petitioner. Now, my lord, this is not the security interest of the petitioner cannot be made the subject matter of arbitration. It is not an arbitrable dispute. This is what my lord Booz Allen holds in paragraph.
what about interim measures with regard to that?
So, my lord, if the final relief cannot be granted, my lord, no interim relief can be granted, my lord. This is settled law, my lord. One paragraph of my lord Cotton Corporation, which I find
Yes,
trouble your lordship with.
yes.
Cotton Corporation. 1983, और एक copy है? 1983, 4 SCC 625. Kindly come to paragraph 10, please, my lord, at page 635. 10.
Yes,
About 10 lines from the top of that paragraph, my lord, paragraph 10, towards the right-hand side. It is indisputable.
yes.
It is indisputable that temporary injunction is granted during the pendency of the proceeding, so that while granting final relief, the court is not faced with a situation that the relief becomes infructuous, or that during the pendency of the proceeding an unfair advantage is not taken by the party in default or against whom temporary injunction is sought. But the power to grant temporary injunction was conferred in aid or as auxiliary to the final relief that may be granted. If the final relief cannot be granted in terms as prayed for, temporary relief in the same terms can hardly, if ever, be granted. And then, the Constitution benches notice. So this is the proposition and the principle fairly well said. Similar to what Booz Allen says, that a claim arising out of mortgage cannot be referred to arbitration. It has to be decided in an ordinary civil suit. Similar, a fortiori, the tribunal, the arbitral tribunal, would not have the jurisdiction to grant any relief in aid of the security interest of the petitioner. And that is the self-same relief which is now being sought before your lordship, because the tribunal has not been constituted. But after the 2015 amendment, the tribunal has the same powers as the court under section 9. If your lordship compares section 17 as it now stands with section 9, which was always there, the reliefs are identical. This section 9 is brought in only, and section 9 has been brought in, although the words are very wide. When section 17 was amended, section 9 was also amended to provide for 9 subsection 3. Once the tribunal has been constituted, the court shall not entertain an application under subsection 1 unless the court finds that circumstances exist which may not render the remedy provided under section 17 efficacious.
But have I not already entertained the matter?
Yes, your lordship has entertained the matter.
That ArcelorMittal,
I'm not.
ArcelorMittal, if court, I don't remember the paragraphs, but if the court has already entertained the matter,
Yes. Yes,
then
my lord,
that clockwise, anti-clockwise.
yes, will not apply. But here in this case also, that difficulty does not arise because the tribunal has not been constituted.
Yes.
All that I'm trying to show, is the reliefs which are granted available to the petitioner under section 9 are also available to the petitioner under section 17. Why the section 9 is invoked is either before, during, or after the pendency of the proceeding. the
Yes.
court is approached. But the legislature is aware that once it gives the same powers to the tribunal, the legislature brings in a caveat in subsection 3 that the court shall not entertain an application unless the court finds that circumstances exist which may render the remedy provided under section 17 efficacious. So, my lord, the point which I make is this, my lord, if the tribunal is not competent to grant a relief in the main proceeding, in the arbitral proceeding, if no relief to secure the security interest could be made, then no such relief can be granted by the Honorable Court also in an interim, as an interim protection.
The only difference which I find, you can correct me, Mr. Thakkar, is that they are not really, whatever the pleadings are,
My lord,
they are not really trying to enforce the mortgage. What they are seeking now, as I understand, is that you will not deal with those
security
whatever,
assets.
the flats and the garage spaces until there is some movement in terms of the arbitration clause.
I follow that, my lord. To that, my lord, I only have this submission to make, my lord, that I place those paragraphs only to show your lordship, my lord, this right is founded or this application is made to protect the security interest.
Yes.
That is the pleading, my lord. That is why I did not add or subtract anything. I read out 28, 29, 30. If the
Yes.
security interest cannot be the subject matter of arbitration, then a fortiori, my lord, a section 9 application would not lie to enforce that same security interest, my lord. Protection, the interim protection is aid of enforcement of the mortgage, my lord.
Yes.
The case is very squarely made out in the petition that either the respondent is dealing with the property or, my lord, other authorities are dealing with the property. My lord, one more paragraph, my lord, paragraph 31 at page 15. Your lordship kindly sees, my lord.
Yes.
If notice of the instant application, your lordship has
Yes.
if notice of the instant application is given to the respondent would forthwith create third-party rights in respect of the said assets and would otherwise take far-reaching steps to dilute and or interfere with the security interest of the petitioner. It's the common refrain. Then kindly see the next. Various steps may also be taken by various other creditors and statutory authorities which may have the effect of interference and or dilution and or dissipation of the security interest of the petitioner under the said assets. In such an event, all efforts of the petitioner to recover its dues shall be rendered infructuous. Similarly, if the petitioner seeks to enforce and or protect its security interest, the remedy is in a mortgage suit in which it can obtain any sorts of injunctions it seeks in this proceeding to protect its security interest in the interregnum of the suit being finally decided. But those reliefs, in my respectful submission, my lord, cannot be granted by the tribunal, mortgage being a subject which is not arbitrable, and therefore any relief in respect of the mortgaged assets also, my lord, cannot be granted.
Very good.
Those are my submissions.
Mr.
I'm not making any arguments on the merits, my lord.
No, that's all
Submissions
right.
were made on.
This is I will record that.
Please.
Mr. Shah, can you come back on Monday because I have to dictate an order. I had kept 11:15 for that.
Well, kindly then keep it on Wednesday. Well, Monday,
Wednesday.
Tuesday, I might be in some difficulty.
Yes. On Wednesday, you just, and
I just take 5 minutes.
don't
for that.
take too much time because then.
No, no,
yes.
I just take 5 minutes.
Learned counsel appearing for the respondent has taken a point of maintainability of the present application. Stop. The point being that the petitioner cannot seek to enforce its security interest in terms of a mortgage of a certain number of flats and garage spaces, since the Supreme Court has decided that suits for mortgage and enforcement thereof cannot be decided by an arbitral tribunal. Stop. Next, list this matter on, what did you say, 19th?
Well, at 19th, yes.
List this matter. The court will decide the preliminary point first before going into the merits. Stop. Next, list this matter on 19 July 2023 to hear, as prayed for, to hear learned counsel appearing for the petition.
Straight.
Item number 2, for orders, Mohit Mal versus Mohit Lal Rathi and another.
M22.
This is an application filed by the petitioner under Section 9 of the 1996 Act for an order restraining the respondent number 2 bank slash Small Industries Development Bank of India within brackets SIDBI, SIDBI, close brackets, from giving any effect to a notice of invocation dated 27 June 2023. Stop. The respondent does not seek any other relief and submits, through learned counsel, that the other relief prayed for in the form of a direction on the first respondent to pay a sum of rupees 1.75 crores can be decided in the arbitration. Stop. Next, the impugned notice of 27 June 2023 issued by the respondent number 2 slash SIDBI, SIDBI, they can even cause it, is a notice invoking, is a notice enforcing a deed of guarantee executed between the petitioner, the respondent number 1, and others as guarantors with the with SIDBI on 23rd March 2017. Stop. Next, the admitted facts in the present application are as follows. Stop. The petitioner is, next paragraph, the petitioner is a director, was a director and a major and a majority shareholder of a company, namely Karani Tectex Print Private Limited, paragraph 1. Stop. The petitioner entered into a share purchase agreement, capitals, dated 19th July 2019 with the respondent number 1 for selling the petitioner's shares in the said company. Stop. The share purchase agreement, SPA korada, prothombar SPA debe. SPA describes the respondent number 1 as the purchaser, quotation marks, and the petitioner as the seller, close quotation marks. Stop. The petitioner thereafter resigned. Now, the respondent number 1 purchased, bought out, BOUGHT, bought the petitioner out, in terms of the SPA, and the petitioner resigned from the company on 13th December 2019. Stop. The company accepted the resignation by an earlier letter dated 25th November 2019. Stop. The fact of resignation, the fact of the petitioner's resignation from the company was informed to the respondent number 2 by the company by a letter dated 2nd January 2020. Stop. The petitioner also informed the bank of the said fact by a mail of 8th July 2020, stating that the petitioner's name will be replaced by the current management of the company, and requested the bank to release the petitioner's collaterals and personal guarantee. Stop. The petitioner reiterated the request for release of personal guarantee by a letter dated 10th July 2020. Stop. Next, the issue which arises is whether the respondent number 2 bank can or is entitled to invoke the deed of guarantee against a petitioner after the respondent number 1 bought the petitioner out from the company and made and all such facts were made known to the bank. Stop. The bank, in fact, replied to the petitioner's mail/letter on 14th July 2020, stating that the bank will consider the petitioner's proposal for release of security on the company providing additional security to the satisfaction of the bank. Stop. The bank also stated that it will release the petitioner's security upon approval of the competent authority and creation of charge on a new security. Semicolon, this by way of a mail of 19th October 2020. Stop. Next, apart from the admitted facts where the bank was duly put on notice of the petitioner's exit from the company as a director and shareholder, comma, the SPA contains certain clauses which are significant for deciding the rights of the petitioner to claim relief against the bank. Stop. Clause 2.3.1 of the SPA provides that all liabilities of the company, past, present, and / or future, shall now be borne, BORNE, by the purchaser, within brackets, the first respondent, close brackets, including but not limited to statutory and financial, statutory liabilities and commitments to financial institutions, to private and public financial institutions. Stop. Clause 2.3.3 further provides that the purchaser, within brackets, the respondent number 1, close brackets, shall ensure release of all personal guarantees and collaterals of the seller, within brackets, petitioner, close brackets, on behalf of the company from financial institutions latest by 31st March 2020. Stop. Clause 4 provides for indemnification and damages. Page 39 onwards, 39-40. In indemnification and damages, whereby the indemnifying party / defaulting party agrees to indemnify and defend the non-defaulting party from against damages, losses, liabilities and obligations. Stop. The clauses hence provide for a clean and complete exit of the petitioner from all liabilities, and for the respondent number 1 / purchaser taking over these liabilities. Stop. Admittedly, the respondent number 1, now it appears from the cause of action brought to the court that the respondent number 1 has not discharged, may not have discharged his liabilities under the SPA. Stop. Next, whatever the case may be, the bank, respondent number 2 bank, cannot plead ignorance of the admitted facts. Stop. The letters of the bank would show that the bank was put on notice of the petitioner selling out his shares in the company in favor of the first respondent, and the bank promising to take, and the bank intending to take appropriate steps upon certain other conditions. Stop. The bank hence cannot invoke or enforce the guarantee against the petitioner long after the petitioner the liabilities of the petitioner including under the guarantee, were to be taken over by the respondent number 1. Stop. Next. What there shall accordingly be an order restraining the respondent number 2 bank /SIDB from giving any effect or further effect to the impugned notice dated 27 June 2023. Stop. What do you propose to do with the section 9? Mr.
My
Gu?
lord, may I dispose of the section 9. I'll take steps by issuing section 21 notice and refer the rest of the matter to arbitration against respondent number 1.
The interim order shall be in place for a period of 4 weeks from date. Yes. Now, since, learned counsel appearing for the petitioner submits that the petitioner will immediately take steps for referring the parties to arbitration, the interim order shall be in place for a period of 4 weeks from date for the parties to take requisite steps under the arbitration agreement, which is contained in clause, which clause is this?
My lord,
Clause C.
8,
Clause 8,
dispute resolution
clause 8
at page 44.
of the SPA. Stop. AP number 421 of 2023 is accordingly disposed of in terms of the above. Stop. Next, since the bank has not been called, since affidavits have not been called for, the allegations contained in the application shall be deemed not to have been admitted.
My lord, may I just pray something, my lord? If lordship is granting this interim relief, can it be till the constitution of the arbitral?
No,
Because
4
30
weeks.
days I have to give notice. So once the 21, after the lapse of 30 days, I have to take out application.
Give
and
me the maximum time period, please.
My lord, at least 3 months, my lord, because
Not at all.
section
Then no
11 I will-
interim relief.
Then-
The interim shall be in place until constitution of the arbitral tribunal, but not later than September 2023. Ms. Gopi, you argued very well. Thank you.
Lord, I'm grateful, my lord.
Item number 7, Phoenix Overseas.
I was addressing your lordship on the last occasion. I'm opposing a section 11 application only on one ground.
What
That
was
is
the- what-
jurisdiction.
Just 1 minute, Mr. Chaudhary. What was your submission?
My lord,
Did you argue the matter?
No. This
No.
was my application. This is my application under section 11 for appointment of an
Very
arbitrator.
well. If Mr. Chaudhary is taking.
He has
a
taken the
preliminary-
point of,
Yes,
yes,
then I will have to hear.
jurisdiction, your
Yes.
lord.
That's my
My lord,
only
only
point.
one day, my lord, a day time be given to reply to his argument. That is all. Any day subject to your
Whatever.
lordship.
Yes, Mr. Chaudhary.
My lord, the arbitration clause refers to the rules of, my lord, an organization called SOPA. I have annexed,
Soybean.
Soybean, my lord. I have annexed the rules in my affidavit in opposition. Lord, the clause, if your lordship is pleased to see, my lord, page 14 of the affidavit in opposition.
Yes,
These are the rules.
yes.
Rule 5, my lord, says that arbitration proceedings shall be at the headquarters of SOPA or at other place as may be decided by the arbitrators.
Yes.
My submission, my lord, is this.
And
Headquarters of-
why have I written Indore, Mr. Chaudhary?
That's because the headquarters are at Indore.
Very well.
So that, my lord, is the seat of arbitration, is my submission. The second part of the sentence, or at any other place as may be decided, would, my lord, be venue for convenience of the learned arbitrators.
So the or, what follows after or will be the venue?
Will be the venue, if at all it is chosen. And that, my lord, doesn't change the seat. seat, my lord, is anchored at Indore. So therefore, my lord, lack of big seat operates as a forum selection clause, and therefore, my lord, the application cannot be made in this honorable court. This is my argument, my lord. May I, my lord, straight away come to, in fact, let me place, my lord, while your lordship has the affidavit open, three further clauses, my lord. Clause 6.
Yes.
Clause 6, my lord, says, subject to other provisions in this rule, each party to the arbitral proceeding should appoint one arbitrator from the panel. And then, my lord, chairman will appoint, etc. Then, my lord, on the next page, clause 13. SOPA would keep the records of all arbitration cases conducted under these rules for a period of 5 years.
Yes.
And then clause 14, secretary or office of the association shall have authority to receive payment, etc., etc. Then Lord, page 17, clause 29. All awards by arbitrators shall be in writing on an official form issued by a secretary of the association, signed by the arbitrators.
29.
Stamp
Clause
29.
29 is the party seeking adjournment shall pay rupees 3,000.
Lord, I'm sorry, it is 20, Lord.
20.
I'm sorry,
Yes.
my mistake.
Yes.
All awards by arbitrators shall be in writing on an official form issued by the secretary of the association, signed by the arbitrators in terms of clause 11.1 herein before, and duly stamped and attested by an officer of the association. Now, all of this, my lord, I have cited to show that the head office is where, my lord, the arbitral process is anchored. Records, my lord, will be kept there. Award will be made, my lord, in a particular way on a form, my lord, which is available from there. And, my lord, costs have to be paid there. So, my lord, the process is, my lord, anchored at Indore. Now, my lord, three, my lord, bullet points really to show that this is not, the second part of the sentence is not venue, but is, and the first part is seat and the second part doesn't change it. Number one is, if the agreement says
Yes.
that an arbitral process will be held at a geographical location, shall be held at a geographical location, then that would be the seat.
Yes.
Number two, in this case, my lord, facts, my lord, and the agreement between parties show that it was intended that the arbitration would be anchored in Indore. That I've shown the clauses. And three, my lord, there is no contrary indicia which would have the effect of
Yes.
the clause being read to mean that Indore is not the seat but is the venue. These are my three arguments.
Yes.
If, my lord, head office, that is Indore, is read to be the seat, my lord, it is settled law, my lord, that it operates as a forum selection clause. And because of, my lord, section 11, it will not, my lord, be this honorable court, but
So if I were to read that particular clause, Mr. Chaudhary, then you're saying that there is no way one can say that Indore is the venue.
yes. Yes.
And if Indore had been the venue, then the petitioner could have come to this court because venue is just a matter of convenience for the tribunal.
Yes.
But if it's seat, then it's rooted. to
Yes,
that
it's
place.
rooted, anchored, and that will operate as a forum selection clause. The question is whether the second part of the sentence would really destroy the first part of the sentence of that clause. To
Whether
mean that
whether
it's-
what follows after or dilutes what comes before.
Yes. If it does, then it is no longer seat and my learned friend is free to go, my lord, wherever else he wishes to. But if it is seat, then he has to, my lord, go there. That is, my lord, the situation. My lord, may I cite, my lord, the first authority, which is BGS Soma. I've given all the cases day before yesterday to my learned.
BJ Soma, Justice Banerjee,
This is
Justice
Justice
Nariman.
Justice Nariman, Justice Bose, and Justice Ramasubramanian.
Yes.
Lord, paragraph 61 onwards. In fact, all the other authorities are considered here. So I will, my lord, extensively place this judgment and refer to the other authorities. Lord, 60 onwards, really, page 289 of the report.
Yes.
Lord, paragraph 60, my lord, this is a chapter which deals with, my lord, tests for determination of seat.
Mr. Chaudhary, why is this so warm? It's fresh off the oven. What is it? This whole decision.
Lord, I think they've just taken the printout.
Yes.
And I'm lucky that the printout has come, and I'm not, my lord, trying to pray for an adjournment on that ground.
Yes.
My lord, 60, my lord, judgments for the English of the English courts have examined the concept of juridical seat and have laid down several important tests. Judgment of Justice Cook in Joshua states, London arbitration is a well-known phenomena which is often chosen by foreign nationals with a different law, such as the law of New York governing the substantive rights of the parties. This is because of, my lord, different reasons. Then, my lord, I'm omitting that. Paragraph 61, it will thus be seen that whenever there is an express designation of a venue and no designation of any alternative place as seat, combined with a supranational body of rules governing the arbitration and no other significant contrary indicia, the inexorable conclusion is that the stated venue is actually the juridical seat of the arbitral proceeding.
So here it's saying that the venue is defined, but not the seat.
No.
Shashwat.
Yes, Shashwa Milord says this, wherever there is a express designation of a venue
Yes.
and no designation of any alternative place as the seat,
Yes.
combined with a body of rules governing the arbitration, then that venue is the seat and no other contrary indicia, then that venue is the seat. For example, my lord, if I say,
You want to argue the opposite here.
no, my lord, I want to argue that there is no contrary indicia. So therefore, my lord, if I say London arbitration,
Yes.
if I say London metal exchange rules apply, or arbitration will be in London under London metal exchange rules,
Yes.
or in Singapore under SEAC, then, my lord, Singapore is the seat of arbitration. That's not what paragraph 61 says. However, my lord, if we say that all of this and also say that the seat can be further chosen by the parties, or there is a contrary indicia, then that, my lord, destroys the argument that Singapore or London was the seat. So, place mentioned, read with rules, and shall be held over there in the absence of a contrary indicia in the agreement is seat. This is my argument. This is what Shashua says, and my lord, the further.
This is Shashwa versus Sharma.
This is, my lord, Shashwa versus Sharma. Yes. Now, the encouraging thing is we find so many, my lord, judgments of the English courts now with Indian
Yes.
names.
Yes.
In next, my lord, Enercon, my lord, explains this. Please see, my lord, paragraph 62. In Enercon, the arbitration clause between the parties read as follows. All proceedings in such arbitration shall be conducted in English. Venue of arbitration proceedings shall be London. The arbitrators may award costs, etc., that substantially prevail on merit. The provisions of the Indian Arbitration and Conciliation Act shall apply. The court in Enercon began its discussion on the seat of the arbitration by referring to Shashua and then referring to the conflict of laws by Dicey, Morris and Collins. My lord, please see the first paragraph. Moreover, as Justice Cook noted, this conclusion is consistent with the views expressed in the conflict of laws by Dicey, Morris and Collins, such and such edition, where the authors state that the seat is in most cases sufficiently indicated by the country chosen as the place of arbitration. For such a choice of place not to be given effect as a choice of seat, there will need to be clear evidence that the parties agreed to choose another seat for the arbitration and that such a choice will be effective to endow the courts of that country with jurisdiction to supervise and support the arbitration. So, Lord, if you choose a place, that is the seat, unless the agreement, Lord, would suggest otherwise. In international arbitrations, it becomes, Lord, more important because the judicial system which will support the arbitral process, Lord, is decided on that basis. Here it's, Lord, section 11 appointment only, and then the further section 34, section 9s, etc. So, Lord, please see now, Lord, 64. The court in Enercon then held that although the word venue is not synonymous with seat on the facts of that case, London, though described as the venue, was really the seat of the arbitration. This was for the reason that London a neutral place, etc. So, my lord, venue is read as seat.
Yes. So, Mr. Chaudhary, the logic seems to be that one is designated but not the other.
Yes. If you designate one and don't destroy it by something contrary in the agreement, then that is the seat. This is, my lord, the sum and substance of it. Now, my lord, I'll quickly...
And if the venue is designated and not the seat, then the venue becomes a seat.
Yes.
And vice versa.
Yes. Venue is designated, nothing further is mentioned, that becomes the seat. Because it's the intention of the parties to anchor the arbitration there.
And for that anchoring, you need what the Supreme Court says, or rather Shashua described as a supranational body.
Yes.
So if it's a SIAC, then Singapore. If it is the Malaysian arbitration body, then Kuala Lumpur.
Yes.
And so on and so forth.
Yes. Here, my lord, it's SOPA. Therefore, Indore. Therefore, my lord, section 11. Now, my lord, I don't think I should, my lord, take too much time reading it. But, my lord, now, my lord, kindly see paragraph 63. My lord, in fact, I've placed paragraph 63. My lord, paragraph 69 now, my lord. The court in Process and Industrial Developments Limited then held that the gas supply agreement provided for the seat of arbitration to be in London, inter alia, for the following reasons. It is significant that clause 20 refers to the venue of the arbitration as being London. The arbitration would continue up to and including the final award. Clause 20 does not refer to London as being the venue for some or all of the hearing. It does not use the language used in section 16(2) ACA of where the tribunal may meet or may hear.
ACA? What is ACA?
You know, the Arbitration Conciliation Act, the English Act.
This is 1996 one or 1994?
This is the 40. This is the English Act, my lord.
Yes, yes, the 1996.
Oh, yes, it's the same year, right?
Yes.
It's 96.
Yes,
It's the same year.
yes.
Clause 20 provides that the venue of the arbitration shall be London or otherwise as agreed between the parties. Now, please see this. Shall be London or otherwise as agreed between the parties.
Yes.
If the reference to venue was simply to where the hearings would take place, this would be an inconvenient provision and one of which the parties are unlikely to have intended. It would mean that hearings had to take place in London, however inconvenient that might be for a particular hearing unless the parties agreed otherwise. The question of where hearings would be conveniently held is, however, one which the arbitrators ordinarily have the power to decide, as indeed is envisaged in section 16(2) ACA. this is likely to be much more convenient arrangement. Clearly, if the parties were in agreement as to where a particular hearing were to take place, that would be likely to be very influential on the arbitral tribunal. But if for whatever reasons they were not in agreement, and it is not unknown for parties to arbitration to become at loggerheads about very many matters, then it is convenient for the arbitrators to be able to decide. If that arrangement was to be displaced, it would, in my judgment, have to be spelled out clearly. Accordingly, the reference to the venue as being London or otherwise as agreed between the parties is better read as providing that the seat of the arbitration is to be England, unless the parties agree to change it. This would still allow the arbitrators to decide where particular hearings would take place, while providing for an anchor to England for supervisory purpose unless changed. Now, this is a very important judgment, my lord, which effectively says that venue, when you say arbitration shall be London or otherwise as agreed between the parties, that shall be London shows, my lord, seat is London. No, I've got the judgment. Okay, now.
This is the process and
Yes,
industrial.
my lord.
That one.
I'll give you the judgment. I'm sorry, Ashwin. My lord, the procedural orders are mentioned first. Paragraph 48 at page 14 of the judgment.
Mr. Chaudhary, give her the citation so that she can
That
get it.
I'll just
Paragraph?
give her the copy. No, I should
Yes.
have- 2019
Paragraph 48. Paragraph 48
For 48, not
at
page,
page
14.
14.
Provision to market. The
Yes.
arbitration rules, my lord, are quoted then. Article 16, unless parties have agreed upon the place where the arbitration is to be held, such place shall be determined by the arbitral tribunal. That's a statutory right. You know, section 20 of our act also says
Place
That-
of arbitration.
place of arbitration. Parties are free to decide.
Yes.
Similar. Now, after this, my lord, that I'll just cross over from estoppel. My lord, paragraph 85.
So paragraph 48 and then 85.
85. The GSP is written in English, as I have said, it was not an issue that the
What is GSP?
but I think the contract, I'll just check for that. GSP is the I think it is the contract. It's below gas. Yes, gas supply and processing agreement,
Where are you getting that from?
paragraph 2. 3.
Yes. Yes.
The GSP is written in English. As I have said, it was not an issue that the question of its construction is governed by Nigerian law. However, it was undisputed before me that Nigerian principles of construction should be taken to be the same as those of English law. In the present case, there was no evidence that those principles are different from those of English law. And so, on the present hearing, they are to be presumed to be the same. Furthermore, Mr. Satansat suggested that this presumption probably reflected the reality. Applying the approach to construction of English law, I conclude that there are significant arguments the other way. The GSPA provides the seat of arbitration to be in England. I say this for the following principal reasons. 1. It is significant that clause 20 refers to the venue of the arbitration as being London. The arbitration would continue up to and including the final award. clause 20 does not refer to London as being the venue for some or all of the hearings. It does not use the language used in section 16(2) of the Act, of where the tribunal may meet or may hear witnesses, experts, or the parties. I consider that the provision represented an anchoring of the entire arbitration to London rather than providing that the hearings should take place there. So it's not anchoring.
So says that there is no need to differentiate between seat and venue, that everything should be in London.
Yes. And that's for convenience. Second part is, my lord, statutory recognition. I'm sorry, my lord, it's recognition of the statutory mandate that you can't tie down parties or the arbitral tribunal, which is why the second part comes in a lot of cases. But that doesn't mean that there's any detraction. It's not a contrary indicia. So seat remains seat because it's intended that the arbitration would be anchored in London. In this case, in Indore, records there, we use their forms, we pay the fees in Indore. The award will be made in a particular way, not at Indore. So intention of the parties is SOPA, and SOPA has rules which anchor the arbitration in Indore.
Headquarters.
Headquarters. Now, my lord,
Mr. Chaudhary, how much more time will you take?
half an hour, my lord.
Half an hour. And how many
got
more
some-
decisions do you have?
6, my lord.
6.
6. But I'll be quicker.
Are you saying this to have it on some other day?
No, my lord, I've given him the judgments day before yesterday. For a change, I'm ready.
Very well. One more decision and then you can do it on some other day.
The clause 20 provides that the venue of the arbitration shall be London or otherwise as agreed between the parties. If the reference to venue was simply to where the hearings should take place, this would be an inconvenient provision and one which the parties are unlikely to have intended. It would mean that hearings had to take place in London, however inconvenient that might be for a particular hearing, unless the parties agreed otherwise. The question of where hearings should be conveniently held is, however, one which the arbitrators ordinarily have the power to decide, as indeed is envisaged in section 16(2) of the Act. This is likely to be a much more convenient arrangement. So the second part is convenience. Clearly, if the parties were in agreement to where a particular hearing were to take place, that would be likely to be very influential on the arbitral tribunal. But if for whatever reason they were not in agreement and it was not unknown for parties to arbitration to become at loggerheads about many matters, then it is convenient for the arbitrators to be able to decide. If that arrangement was to be displaced, it would, in my judgment, have to be spelled out clearly. Accordingly, the reference to venue as being London or otherwise as agreed between the parties is better read as providing the seat of arbitration is to be England, unless the parties agree to change it. This would allow the arbitrators to decide where particular hearings should take place while providing for an anchor to England for supervisory purposes unless changed. The reference in clause 20 to the provisions of the rules of the Act is not inconsistent with the choice of England as the seat of arbitration. The non-mandatory provisions of the Arbitration Act are displaced by that provision, but mandatory provisions apply. Then we learn the other Shoshua is followed, Enercon is followed, and we learn this is the finding.
Mr. Chaudhary, choose a short case, please.
Lord, I'll come back on the next step.
Yes. Tell me when,
Not whenever convenient to you.
because I have my examination and judgment debtors today, so
Sir,
I
any day, my lord, any day, time convenient, I'll come.
No, I
I'll
want
come
to
with a note also.
get on with my list.
Monday, subject to your lordship's convenience.
Yes,
Mr.
I am
Chaudhary.
here, my lord. I'll
No,
come.
no, not your convenience, the
No.
person who's making submissions.
I am my lord's
No, no,
convenience.
very well. That Monday I'll come.
I've asked
If
for
it
my
is
lord's
convenient to your lordship.
Yes, a learned counsel appearing for the respondent who has taken a preliminary point of the maintainability of the application in this court comma, namely, comma, the Calcutta High Court, comma, will continue with his submissions. Mr. Chaudhary, 19th or 20th? Which day? On 20th July 2023.
Item number 8, Mrs. Zillion Infra Projects.
May it please your lordship, I appear for the petitioner. This is my application.
Lord, I appear for the
1 minute, please. Yes. Yes.
I appear for the petitioner, your lordship. This is my application under section 11 of the arbitration. and
Section 11,
conciliation.
yes.
On the last occasion, the respondents had submitted
I
that they,
can't hear you. Microphone, please.
on the last occasion, your lordship, the respondents had submitted, the respondent had submitted that they will not file an affidavit. Your lordship.
Yes, yes. Mr. Gupta, had you started or will you start today?
No, my lord, I had just, I have instructions from my advocate on record, my lord, that an tribunal may be constituted, my lord.
Yes.
And the point of limitation and that the other point, my lord, since they have not disclosed the agreement and the petition, my lord, the NN global point, these 2 points may be kept open so that I can take it before the learned arbitrator.
Very well. What is the agreement? What is the dispute? I have to mention
Your
that in the order.
lordship, the dispute is regarding unpaid dues under works, unpaid dues for works undertaken by the petitioner under a notice inviting tender. Your lordship, we've disclosed the notice inviting tender, but the GCC, which was an annexure to the notice inviting tender, has not been annexed. I have a copy, your lordship. The letter of intent to award has also been discussed.
This is governed by the GCC. Why?
The
But-
arbitration, sorry, your lordship, arbitration clause is contained in the GCC, clause 49 of the GCC.
Yes, show me the clause, please.
My lord, may I, my lord? My lord, we have already also, my lord, indicated, my lord, the agreement, arbitration.
Clause 49 of the
My lord.
GCC.
My lord,
Yes,
that
my
is
lord.
page 7 of my petition, my lord. And it is also, my lord, in the notice also.
I got the GC. I cannot take.
Notice, what notice?
My lord, in section 21 notice, my
Section
lord, that
21.
is page, my lord, 64, my lord, relevant page, my lord. Arbitration clause is there, my lord. But no reply to the notice, my lord.
64.
64, my lord.
64 is not the first page of the notice. Where does it start?
My lord. My lord, 55, my lord. It starts from, my lord, page 55, my lord. It is sent through email, my lord, and the copy of the notice is attached to the mail, my lord. It starts from 56, my lord.
And 12th October 2022.
Yes, my lord.
My lord.
And why did you file it so late?
My lord, moratorium period is, my lord, petitioner is under, my lord, insolvency proceedings, my lord.
Petitioner.
Petitioner is insolvency proceedings. We have also annexed the minutes of the meeting, that is page 24. That is Committee of Creditors meeting, my lord. The minutes of the meeting, my lord. Annexure C, page 24, my lord.
Yes, so now you're out of moratorium or you're
No,
still in it?
we're still in moratorium.
Moratorium.
My NCLT order is, my lord, page, my lord, page 14. Annexure B.
And the dispute is with regard to what is the work? I don't have to ask you so many questions. Please tell me the facts.
My lord, fact is, my lord, there was a tender, my lord, for structure,
Mr.
construction.
Gupta, tell me the facts, please.
My lord,
Yes.
it was a work for construction, my lord, of a structure at Odisha, my lord.
Yes.
So, my lord, they had certain claims certain payments were made, last of which was made in two thousand
No, no,
six.
who's the contractor?
No, he's the contractor.
Yes, you say that.
He's the
Yes,
contractor.
Yes,
Last of the payments was made in 2016.
yes.
They have admitted it in. I'm sorry, my lord, 2000,
Payment has been made, my lord.
2017, February 2017, my lord.
Yes.
Now, my lord, the completion certificate was given in 2014, last payment made in 2017, my lord. Now, the point of limitation is that despite the 3-year period from the last date of payment has expired, and they have issued the 21 notice only in 2022, my lord. So that's the point of limitation which I wanted to.
So you're saying it's not a life claim?
It's not a life claim, my lord. However, my lord,
My lord,
under the instructions, my lord, we will take this because since I have not used an affidavit and shown that this was the full and final payment, my lord, I would want to take this point before the learned arbitrator.
My lord, your lordship kindly see, my lord, that is, we went to, my lord, insolvency proceedings, that is order appearing, my lord, annexure B, my lord, that is 5th February 2019, my lord.
Yes. Very well.
February 2019, my lord. My lord, thereafter, my lord, it's a moratorium period is on, my lord. We are
Mr.
out of,
Gupta is, you're out of moratorium?
no,
You're in
we are
the,
in moratorium, my lord.
within moratorium? Yes, learned counsel appearing for the respondent does not resist the application for appointment of an arbitrator. Stop. The only point is that the only request is that the point of limitation should also be decided, should also be considered by the tribunal. Stop. Next, the dispute between the parties arises out of a tender floated by the respondent for construction works in Odisha. Stop. The petitioner was engaged as the contractor, being the successful bidder, and the dispute is on unpaid bills. Stop. The respondent issued a completion certificate in 2014, and the last payment was received by the petitioner in February 2017. Stop. The petitioner, however, went into CIRP under the IBC, 2016 on and from 5th February 2019. Stop. The petitioner is still in CIRP. Stop. The arbitration clause, which page?
My lord, he is referred to
7.
the arbitration clause in his notice.
Yes,
page 56.
next, Aki paragraph. The petitioner sent a notice under section 21 of the 1996 Act to the respondent on 12th October 2022. Stop. The notice sets out clause 49 of the GCC, which is for arbitration. Stop. The respondent did not reply to this letter. Stop. The next, learned counsel appearing for the respondent submits that the claims raised by the petitioner are barred by limitation, but agrees to have this point referred to the tribunal as well. Stop. What is the amount of the claim?
3,61,000.
No, my
3
lord.
crore 61.
3
5
crore.
crores, my lord. 5
5
crores, and
crores.
that is appearing at page 63, my lord.
Very well. Next, AP
Principal 361.
ওপরে AP নাম্বারটা লেখা নেই? AP 363 of 2023 is is allowed and disposed of by appointing blank to act as the arbitrator to resolve the disputes and differences between the parties, subject to the arbitrator communicating his consent in the prescribed format to the registrar, original side within 3 weeks from date. Stop. The petitioner shall communicate this order on the arbitrator by 17th July 2023 with particulars of the contact person with who the arbitrator may be required to get in touch.
I'm grateful. Subject to your lordship's consideration, Lord. Another arbitration proceedings is going on. The tribunal was formed under the orders of this honorable court, my lord. May I just hand over the same parties, my lord, a different contract, my lord. May I just hand over this, if subject to your lordship's consent?
No, so this, you're handing this up for what?
Lord, the name of the arbitrator.
Name of the arbitrator? You want the same arbitrator?
Lord, if my learned.
I leave it to your lordship, my lord.
So this is subject to your lordship's consent. Subject to your lordship.
Very well. Let me consider.
I'm grateful. May I take back the GCC?
Much
Yes,
obliged.
call on the next matter, please.
Item number 9, breach track and tower.
Which is in my section 9 application, Lordship.
Yes,
Affidavits are complete in the matter. Here for the respondent, my lord.
yes.
We had taken the issue of maintainability of this. We had raised the issue of maintainability of this application, my lord. Since, my lord, 6 separate and distinct purchase orders has been clubbed together in the section 9 application as well as in the section 11 application, which is also, my lord, they have.
No,
filed.
with different arbitration clauses.
Yes, my lord, because the clause itself denotes that it is in respect of only that purchase order.
And you have completed your arguments?
No, my lord, we have not commenced.
Yes.
There's an order of injunction that is going on, Lordship. That I'll is- just briefly indicate, Lordship, what is the.
No, have you, if you say preliminary point, then you have to take it. That's what I'm asking. Yes. What is the order of injunction?
Injunction restraining them from, it's going on from 2021, order
Yes.
of injunction restraining them from alienating their assets and
Very well. Yes,
6 purchase,
yes.
For this purpose, my lord, may I first, my lord, place section 7 of the Arbitration and Conciliation Act, which provides for the arbitration agreement. Lord, in this part, section 7, in this part, arbitration agreement means an agreement by the parties
Yes,
to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not.
yes,
An arbitration agreement may be in the form of I'm not relying on that. So what I'm stressing upon is all or certain disputes.
yes,
An arbitration agreement, Millard, in my humble submission between the parties can be as wide as Millard covering any dispute between the parties. It may be contained in only one document, but even other disputes, Millard, it can be wide enough to encompass those disputes as also. On the other hand, the parties by contract, as Millard, the wordings of the arbitration agreement would denote, can restrict the reference, the disputes which can be referred to arbitration with respect to only certain disputes or that contract itself only. Look, in this regard, now may I place the first purchase order, which is at
So
page.
what is the point, Mr. Shahu?
My lord, the arbitration, may I place the arbitration agreement, my lord, because the
Yes,
the terminology of the agreement, the language is important. My lord, all this, my lord, the first purchase order is at page 17.
yes,
So then the arbitration agreement is at page 22. My lord, it is not too legible. So if your lordship kindly takes page 9 of the application, it is set out.
yes,
In the event of any differences or disputes arising out of or in connection with this purchase order,
yes.
the same shall be first amicably settled by mutual dialogue if the
Page
parties.
9.
Page 9, Millie. Let paragraph 31. I'm sorry, Millie, page 8.
Page 8. Why are you
I'm
saying
sorry,
page 9?
sorry, I'm
Yes,
sorry.
yes,
In the event of any differences or disputes arising out of or in connection with this purchase order,
yes,
the same shall be first amicably settled by mutual dialogue. If the parties fail to settle their differences or disputes arising out of or in connection with this order, the same shall be referred to arbitration. And the other purchase orders, my lord, which are annexed to the petition subsequently, my lord, after the one at page 17 contains the similar purchase order, my lord, similar arbitration clause. My lord, it is my humble submission that, my lord, the parties have by agreement restricted the arbitration agreement for reference of the dispute with respect to only this purchase order and not any more. None of the other purchase orders.
So all the purchase orders have different
distinct.
arbitration clauses.
Yes.
And says
Maybe
that
some-
it
sorry.
will govern only that particular purchase order.
Same arbitration clause.
Yes.
Now, it is also, my lord, my learned friend will correct me if I'm wrong. My lord, there is no pleading also that there is a composite or a common single economic transaction between the parties. That is also not appearing in the pleadings.
Like Amit Lalchand.
Yes. And or also, my lord, Duro Felguera, if it is a
Yes.
single economic transaction, then it can be perhaps. But then also, my lord, in view of the arbitration clause, the language of the arbitration clause, in this case, my lord, that also may not be possible to, my lord, construe that.
Yes.
My lord, the only case they have made out, if I may say that, for referring all the 6 purchase orders or clubbing all the purchase orders in one section 9 petition or for arbitration in section 11 is that payments were made ad hoc payments in respect of all the transactions. That in my humble submission, my lord, the Contract Act provides for that. In such situation, what is to be done, how it is to be appropriate or what. That cannot be a sole reason or at all a reason for referring all the purchase orders, which has different arbitration clauses, to arbitration and in the one reference.
Yes.
This, my lord, as
That
far
is all,
that
Mr.
is the case, my lord. I am just
Yes.
sorry. The only difficulty is, my lord, there is one judgment that there was 9 hire purchase agreements referred to arbitration. Ultimately, my lord, in section, my lord, appeal, section 37 appeal, it was set aside. And it was directed, my lord, my advocate on record is, oh, sorry. Lord, will kindly excuse me for a moment.
That refers to Amit Lalchand and all the others.
No, my lord.
No.
No, that was a 2002 judgment, much prior, but this particular aspect was considered. This is a judgment, my lord. The matter of Ajay Kumar Shaha versus Ashok Leyland Finance, reported in 2002 SCC Online, Calcutta 540.
Yes.
May I place this?
No, just give me the paragraph, please.
Lord, will Lordship kindly consider paragraph 3 where the facts are there?
Yes.
It appears that the appellants who are in a hirer in respect of 12 vehicles from the concerned financer being the respondent made an application under section 9 of Arbitration Act. The contention of the applicant before the trial court was that the hirer was in very bad financial condition. Leave may be granted to the appellant to liquidate the outstanding. It appears to us that the learned judge, after hearing the parties, ultimately granted liberty to the appellant to pay up the dues in monthly installments in accordance with the hire purchase agreement itself, which comes to around so and so. The learned judge further directed the receiver will take symbolic possession. It may be recorded in this connection that the respondent financer in trial court raised an objection as to aforesaid joinder of cause of action. It was contended that each of the 12 vehicles is governed by a separate agreement. And in terms of each of such agreements, in case of default, the same is
Yes, where
entitled
is
to
the finding of
termination.
the court? 11,
Yes, ma'am.
9.
The 9 to 11, my lord,
Yes.
under such circumstances, we are of
Yes,
the
I've read it. That they were directed to make separate applications.
yes.
Very good.
Lord, as far as the this maintainability is concerned, my lord, that is all.
Mr.
answer-
Shaha
Yes.
in 3 minutes, please.
Yes, very well, Lordship. Before, Lordship, kindly have a look at the interim order that was passed, because in answer to that question, Lordship, that has been taken, I need to go into the facts, Lordship. Why I need
In
to go
3
into,
minutes.
yes, 3 minutes.
Yes.
Why I need to go into the facts? 6 purchase orders with
Yes.
regard to one single work in question, in which the total value put was around 84 lakhs.
My interim order.
Yes, it went up in appeal.
This is 2021.
Yes.
What have you been doing for the last 2 years?
Extension going on, they have been taking adjournments and all recording the orders.
No, show me the appeal court order, please.
Yes, appeal court's order.
Justice the Chief Justice.
Yes.
So you filed the appeal, what, up to 2 years?
No, that time only.
That time only.
Where is the reasoning part? Yes.
Now, Lordship, 6 purchase orders with regard to one single work in a continuation.
Yes.
The total value that I had,
So now what? Affidavits are complete?
affidavits complete, my section 11 affidavits are complete, all both running together, Lordship.
So this is 11 or 9?
Section 9.
Section 9.
The point that they have raised, it's a very simple answer, Lordship. The intention of the parties, Lordship, let us not go into these judgments for the moment. The intention of the parties, whether they had thought that this arbitration clause is to be separated, or each purchase order is to be dealt with separately or with together, Lordship. 14 reminder notices with regard to payment have been sent by us all together, not a reply to each of the reminders. They have paid. The vital element, Lordship, is in the affidavit reply. Lordship will kindly have a look in the affidavit reply, paragraph 4. They have paid an amount of 32 lakhs by way of one single instrument that is annexed.
Yes.
They have treated this to be paragraph 4. Lordship will kindly have a look. Last 4 lines from the bottom. I'm sorry.
Yes.
Last 4 lines from the bottom. I state and submit that out of a supply amount of 84 lakhs 31,339, respondent paid a sum of 32 lakhs on 27 February 2019. The advocate record of the petition immediately sought instructions from his client as to the mode of payment of the amount of 32 lakhs. The petitioner states that the amount of 32 lakhs was paid by a single check drawn on such and such, check number such and such. The check was collected from the office of the respondent Mr. An employee of the petitioner went to the office of the respondent, collected the check. Being an employee of the respondent, the check is annexed. It is evident that the parties have clubbed together the 6 purchase orders and payment has been made by the respondent as a whole and received by the petitioner in relation thereto. So it was the intention of the parties to club the entire thing together, Lordship. And the instrument is at page, Lordship, the instrument I have annexed. Yes. The instrument is at page 8.
Yes.
This was the instrument that
Very
they
well.
had.
That is all?
With regard to the maintainability, what I am seeking for his Lordship, there is an order of injunction that is going on with regard to the alienation of the assets. I want the order to be confirmed and I want to go to arbitration. I don't know, for my realization of the amount, I want to go to arbitration. Let the arbitrator decide. I have the purchase orders, I have the challans that have been issued, the invoices that have been issued. There is a due of around 50 lakhs and odd that is due. In terms of
50 lakhs.
Yes, with interest it will be more, Lordship, but
And affidavits are complete both in the 9
yes,
and
yes,
11.
9 and 11 both complete. Interest rate will run to 80 lakhs and odd. That is the only sub they have issued, they have raised a dispute that materials were defective. I have rectified them. All are on record and it was treated as a single work. And that is how the payments have been made. 14 reminders, Lordship has indicated in Lordship's order, 14 reminders were made with regard to the entire, all the purchase order being clubbed together and not a single reply.
You're the contractor.
Yes, we had filed a very short notes of arguments at the ad interim stage, Lordship. I do not know whether it is.
Milord, may I seek for only one indulgence, Milord? Mr. Anirban Rai is leading me in this matter, Milord.
No,
Kindly,
for orders on Tuesday.
Yes, Lordship, this was in notes of a very short.
Have you
indicating-
filed your notes?
no, Milord, may I file it on by Monday?
It is
Milord?
there,
I'll
it is
file
already there.
No, I
because
will not look at any notes. I will disregard the notes.
all the
Notes are not
notes-
required in
Very
this
well,
matter.
very much, very.
Yes, learned counsel appearing for the respondent has taken the preliminary point of the petitioner being required to file how many separate
Milord,
applications?
6 separate applications.
Six separate applications for appointment of the arbitrator, as also for seeking interim relief under section 9 of the Act. Stop. Next. This is the arguments have been countered by learned counsel appearing for the petitioner. Stop. Next. List this matter on 18 July 2023 under the heading for judgment.
Highly obliged. Lordship, the section 11 has been tagged together by your Lordship's order.
Yes, affidavits are complete in both the applications filed under sections 9 and 11 of the
Milord,
1996
May I
Act.
only make one
okay.
submission, Milord, as far as Mr. Shah's contention that the parties we referred to arbitration, Milord, the same issue will arise in the section 11 application. If it is not maintainable, Milord, the section 9, Milord, the reference can also not be made. Thank you, sir.
Yes, he has raised the same issue. Lordship, by an order of 12th of June, Lordship had tagged both the matters together, but it is appearing separately today in two different.
Yes, yes, let both the applications appear together on the next date.
Highly obliged.
Stop.
And Milord, that order is only at an ad interim stage before the affidavits were filed. The
I've
order-
heard you
Yes,
after the affidavits on the preliminary point. Yes. Yes, column. next.
Examination of judgment debtors, item number 119, Poonawalla FinCorp.
Appearing on behalf of award holder, last occasion, their advocate appear on behalf of the award debtor. They have submitted that,
Microphone, please.
they have submitted that today their client will present for examination, my lord, but
My
Yes.
lord, he is in Gujarat, some difficult.
Microphone, please.
My lord, I am for judgment data number 2. He is in Gujarat, unable to get the ticket from Gujarat, so he unable to come to court, my lord.
Then I will have to arrest him and
My
bring
lord,
him to
no,
court.
Any date may be fixed, my lord.
No, but didn't you say that on the last occasion?
My lord,
Same thing.
I have told he hasn't got
Microphone,
the,
please.
he hasn't got the reservation, my lord.
What reservation?
Ticket reservation, railway ticket reservation.
But I gave that order on 16 June.
My lord,
Today we are almost 1 month. Then why hasn't he got the ticket reservation?
my lord, he has tried his level best, but he hasn't.
Sorry, I will have to arrest him and bring.
My
him.
lord, my lord, my lord will, my lord, any day, my lord, he,
No,
he
no,
will,
no, no.
he will be present, my lord, before my lord. The affidavit of asset has already been filed, my lord.
Filed?
it
Affidavit
is
of
filed.
assets?
That's why, yeah.
My
Asset
lord,
has
I
been
filed,
filed, that's
my
why the date for examination has been fixed.
My lord,
They have filed affidavit of asset. but
This is the second time that learned, you're the counsel or the applicant?
my lord, advocate on record, my lord.
That the advocate on record of the judgment debtor number
2, my
two.
lord.
has sought for an adjournment. Stop. The reason this time is that the judgment debtor has not been able to get a reservation for travel from
Gujarat, my lord.
last time you said they're based in Mumbai.
Why, yes.
Now you're saying Gujarat.
My lord, he is in Gujarat now at present.
The order says that I've recorded your submission that they're based in Mumbai.
Based in Mumbai, now he is in Gujarat and unable to take. The fact is this, my lord, that
Their address
at
is also saying Ghatkopar, that is in Mumbai.
at present he is in Gujarat. This is over telephone.
I will have to arrest him and get him.
My lord will not
Ye
do,
bola
my lord.
last time.
One more chance, my lord.
Gujarat. Gujarat to Kolkata. Stop. Next, this submission is contrary to the one made on the last occasion when it had been stated that the judgment debtors are based in Mumbai.
Yes.
Stop. Next, list this matter on 21st July 2023 for the judgment debtor number 2 to be present in court. Stop. If the judgment debtor is not present, comma, the court shall issue warrants of arrest, a warrant of arrest to ensure the judgment debtor's presence.
Yeah, good.
Next,
120 Central Inland Water.
But this is my application for execution. The last topic.
I can't hear you.
But it's my application for execution. My lord. The last order, my lord, the judgment debtor was directed to file affidavit of assets in proper form. My lord, they have not filed.
Not filed. Who is appearing?
So the last occasion appeared Rajashree Singhi. Last order, lordship, you can see the last order. 23rd June 2020.
The advocate on record of the petitioner submits that the judgment debtor has not complied with the direction passed by the court on 23rd June 2023. Stop. The affidavit of assets has not been filed in the proper form. Stop. No one represents the judgment debtor. Stop. Was there a warrant of arrest before this?
For this, yes, my lord, there was an order.
I can't hear you, microphone.
My lord, order of arrest was there, my lord. Thereafter, the judgment debtor appeared and give up evidence. But this was not correct as per the.
Yes, list this matter on 21st July 2023 as a last chance. Stop. If the judgment debtor, if the order is not complied with by the returnable date, comma, the court will consider issuing a warrant of renewing the warrant of arrest against the judgment debtor. Stop. The advocate on record of the petitioner will communicate this order on the judgment debtor / his advocate on record by tomorrow. Next.
20 to 24 is the same.
You have to wait. Next.
121,
Same.
Same order.
122,
Same.
123,
Same.
Same order.
124.
Same.
Action equal, one order.
Yes.
Yes, next.
Item number 125 MSTC Limited.
Sir, I am the award holder, my lord.
Microphone, please.
I am the award holder, my lord.
Yes. Thank you. Last order.
My lord, I have filed my affidavit of assets. The concerned director, my lord, who's a principal officer, he's here. My lord, what I had,
Last order, my lord, is for examination of the
yes, let me just
Judgment.
finish.
Yes.
My lord, in the affidavit of assets, lordship will find there's no properties within the jurisdiction of the court. So the examination is to be restricted only to find out if he has some properties within the jurisdiction of this honorable court.
Yes, you do
he's-
that.
Yes, my lord, he's here, my lord.
Yes,
Yes, sir. Yes, sir. I solemnly affirm. Whatever shall I depose.
I shall speak the truth.
I shall speak the truth.
And I shall not conceal anything.
Not conceal.
Use the mic.
Okay.
What is your name?
Srinivas Chaudhary, Kachkuri.
Loudly,
K.
loudly.
Srinivas Chaudhary,
Not
Chaudhary.
Father's name?
KBR Chaudhary.
He's alive?
No,
Yes, KBR Chaudhary.
KBR. KB.
Just speak in the mic.
Yes, sir.
Your age?
58, sir.
58.
Yes.
Your residential address?
277
277.
MLA MP Colony.
MLA
MP Colony.
MLA MP colony.
Jubilee Hills, Hyderabad.
Huh?
Jubilee Hills, Hyderabad.
Jubilee Hills, Hyderabad. What is the pin code?
5000
Hi, 220?
33.
And what do you do?
I am a business.
Mr. Chaudhary,
Yes, ma'am.
you have filed an affidavit of assets dated 30th March 2023. Is that correct?
Have you filed
Yes, madam.
The information contained in this affidavit of assets, according to you, are correct.
As per the balance sheet, it is correct, madam.
Have you disclosed the balance sheet wherefrom you have derived this information in your affidavit of assets?
I did not understand,
Have
madam.
you disclosed the balance sheet accordingly to your?
Repeat the question, যেটা বললাম একবার, just
Wherefrom
repeat.
you have prepared the. Wherefrom have you denied this?
Right.
We have,
No, 1 minute, just listen to the.
Have you disclosed the balance sheet wherefrom you have derived this information in your affidavit of assets?
Have you disclosed in this matter?
but that is an audited balance sheet, madam.
No, no, whether you have
Answer the
disclosed-
question, then
whether
yes.
you have disclosed the balance sheet or not, that is, he's asking. In this matter, have you produced? to the court?
No,
Yeah.
Answer is no. So,
Are you in possession of the balance sheet you just referred to in your answer at the moment?
at that moment, I am not having, madam.
At this moment, I'm not having it.
Which year or what period does this information relate to in the balance sheet on the basis of which you have filed the affidavit of assets?
Which period?
This is 31st March 2022, madam.
Would you be in a position to disclose the balance sheet on the next date?
Yes, madam.
Do you agree to provide an advance copy to the award holder before the next date?
Yes, madam.
Answer the question to the court.
Okay.
Say my lord.
You are a public listed company, sorry, the judgment debtor is a public listed company, isn't it?
No, your honor.
Sorry, public unlisted company.
Yes, your lord.
My lord.
Yes, my lord.
The deponent can't see me, so I can't blame him. Yes.
Mrs. Banerjee look very happy, but.
Which format do you file your annual return? In which format? Oh, do you file your annual return?
It's a regular balance sheet, my lord. Profit and loss and as per a regular chartered account practice, whatever they say.
What is the paid up capital of the judgment debtor company?
It's about roughly 14 crores, madam, my lord.
14 crores.
In that case, I take it that the balance sheet that you file contains the list of sundry debtors.
Yes, my lord.
You will also agree with me that the balance sheet would also contain details of all your assets, movable and immovable.
Yes, my lord.
Kindly come to, I was before that, do you undertake, no, he has already undertaken to give me. Kindly come to page 3 of your affidavit of assets. Paragraph 11 at page 3.
Yes, my lord.
Are these the only bankers with whom the judgment debtor has transactions?
Yes, my lord.
Kindly turn over the page. You have stated here
Yes,
that you are not aware of the full particulars of the bank accounts mentioned in serial numbers 5 and 6 above.
yes,
Is
my
that
lord.
correct?
Yes, my lord.
You have also stated that you undertake to disclose before this honorable court as soon as you gather such information. Is that correct?
Yes, my lord.
Do you have the missing information with you at the, oh, sorry.
Yes, just to give him some time.
Yes. এক minute, শুনে নিন। Do you have the missing information at present with you?
Right now, I'm not having, madam, but maybe soon I'll file it because
Very soon I will file.
maybe one submission.
Please.
Maybe we are not using any of these accounts for the last,
Slowly.
these accounts for the last 7-8 years, almost from 2013-14, we are not using only one State Bank of India, Visakhapatnam branch account only we are using.
Only one?
One
Let
state,
the answer go down, please.
Only one bank?
only,
Individual answer.
only one State Bank of India account is being operated.
Please go slow. Whatever you are saying, that will be recorded. That is being recorded.
Do you undertake to provide an advance copy of the missing details to the award holder before the next date?
Yes, my lord.
Kindly come to page 5 of your affidavit. Paragraph 12. You have stated, you have disclosed the particulars of the debts due to the award debtor. Is that correct?
As per balance sheet, these are correct.
The balance sheet of 2021, you mean?
Yes,
So the amount 15 crores 34,47,143 নিয়েছেন amount is due to the award debtor from the persons mentioned in the list. Am I correct?
as per balance sheet, yes. Yes, my lord.
Who is the person Alok Chakraborty from mentioned in serial number 2 from whom you are the judgment debtor is to receive rupees 1,50,000?
Can I,
Please.
no, can I elaborate on this?
Yes.
Uh,
First you answer my question. Who is he? Where from? And then
He is the, our arbitrator, learned Justice Alok Chakraborty is our arbitrator. As we could not maintain any accountant,
As we could not maintain any accountant.
so whatever that advances we are showing, I mean, whatever the amount it has been shown was written as an advance rather than as a
Written as an advance.
advance paid to the arbitrator, learned arbitrator. Justice Alok Chakraborty has been shown as advance rather than it has been closed.
is it your evidence that Mr. Alok, Honorable Retired Justice Alok Chakraborty is a creditor of the judgment debtor?
Strictly, no, my lord. It's basically accounts mistake.
Please ask him what kind of accounts mistake it is.
Yes. Can you specify what kind of mistake in your account you are referring to?
No, because we did not maintain regular accountant, whatever the figures that are being regular accountant, the figures that are being, the chartered accountant is just carrying forward the thing.
Since when has this figure been carried forward in your mistaken statement of account?
But I cannot say exactly, but I can provide you details soon.
Have you verified the statements before you have disclosed your affidavit of assets?
Because we strictly,
Please answer yes or no, and then you elaborate. You have to answer yes or no, then you elaborate.
no, I did not verify, but I strictly followed the balance sheet, my lord.
I suggest to you that the information provided by you in the affidavit of assets are incorrect, and you have intentionally made these incorrect statements.
This is a suggestion, you may agree or disagree.
I don't agree, my lord.
Who is Mr. Raghunath Ghosh, mentioned in serial number 3 at page 5, from whom the judgment debtor is to receive rupees 3 lakhs?
He is our advocate on record in the arbitration, my lord. The same mistake what happened with Mr.
The same mistake what had happened in case of
Alok Chakravarti, Justice Alok Chakravarti happened repeated here, my lord.
has been repeated here also.
For how many years has this mistake been repeated in your accounts?
Maybe. I have to see and
I have to take this.
For how many years you did not have an accountant, as you mentioned?
last 4 or 5 years, I mean 6, 7 years, we are not having accountant.
4, 5 years or
6, 7 years.
Who was filing your annual return in this during this period?
Our auditor is filing the account.
Please ask him under which specific heads these persons are mentioned under.
Under which specific heads in your balance sheet these persons' names appear?
I mean, amounts receivable under those heads. I don't know about debtors and creditors. Amounts receivable, there will be head that in that head.
So he's saying that he gets money from both Justice Chakraborty as well as Mr. Ghosh.
Yes.
Money from both.
Yes.
To say something, with the leave of the court, wants to add something.
So he can volunteer.
My lord, strictly speaking, they are not supposed to pay, but as we could not close their account, but we could not close their account,
But we could not close their account,
that their names are appearing.
and that is why their names are appearing.
Do you undertake to disclose all the balance sheet from the time when this mistake appeared?
Yes, my lord. Actually, one more thing.
Yes.
All our balance sheets are filed with MCA and you can download it.
Our balances are filed with MCA. It can be downloaded from that.
Otherwise, I will provide you all the balance sheets. It's not a,
Since I do not know from when this mistake was appearing, do you undertake to provide a copy of those balance sheets?
yes, I will provide.
Lord, I will today.
Ms. Day, are you done or will you continue? on
On
the,
the next day, my lord, he undertakes, and let that be recorded. That he'll
Only one
provide.
thing, your lordship, this issue, your lordship, is required to be decided because in the execution application, the other side, your lordship has disclosed that all the assets are outside. So your lordship,
let the examination be complete, then we shall see.
once it is completed, then your lordship, these issues cannot be decided. Your lordship.
No, the examination has to be completed first. Because he is also supposed to disclose all this, saying that all the balance sheets are available in the MCA portal that everyone knows. He's under an obligation. He's on the box. He has to disclose.
He has given an undertaking. he'll disclose.
Yes. The judgment debtor. He's the only one, only judgment debtor. The judgment debtor undertakes to disclose the balance sheets for the last,
Years from where from the mistake up, since the time the mistake.
so ask him from which year?
From which year would you you undertake to disclose the balance sheets from which year?
From whenever that mistake is continuing, I'll provide all the balance sheets. My
Ask
lord.
him from which year mistake?
Maybe, I think it's 2016 or 17, my lord.
Undertakes to disclose balance sheets of the company,
Yes.
From 2016 onwards on the next, on the returnable day. Stop. Advance copies of these balance sheets will be made over to the advocate and record of the petitioner. Latest by, tell me when, Mr. Shengupta? He's staying where?
Lordship, by 21st, your lordship will provide.
By 21st? No, he lives where?
Say Hyderabad.
Hyderabad. So when will he come again? On the, for the,
Whatever your lordships.
latest
4th
by
August.
latest by 21st July 2023. Stop. This is matter on 4th August 2023 for continuation of the examination of the judgment debtor. Stop. Anything else he had said that I will disclose? Something else?
My lord, balance sheet and annual return, I believe.
Balance sheets and annual returns.
Within 21st, you have to disclose it.
Yes. Call on the next matter, please.
120.
No, I'm sorry. He also said the missing information.
Yes, yes.
With regard to the bank accounts.
Lordship, can we, your lordship, disclose by 25th? Your lordships kindly allow this. 4 days.
25th.
25th.
25th of it. The judgment debtor will also disclose the missing, what did he say?
Missing information with regard to the bank accounts mentioned in page 4 of his affidavit of assets.
Will also disclose the information which is said to be missing on the bank accounts as indicated in at page 4 of the affidavit of assets.
Yes, grateful to you.
Next.
I don't know, 126 Punawala FinCorp.
6 manner, I'm appearing on behalf of award holder. In this matter, warrant has been issued against the award dated number 1, and that is pending. I think sheriff has to. Saying manner extension of the returnable date of the warrant. manner, subject to report filed by sheriff. manner.
এখানে কি বলছেন? Accused has sold the property and vacated the. The report says that the judgment debtor has sold off the property and gone off somewhere else. So what do you want to do?
And I have to then find out the alternative address of the award.
I will give you a copy of the report and I can keep the matter on 21st. The advocate on record of the award holder places an order of a coordinate bench dated 24th March 2023, whereby the SP of the local police station SP of police was directed to file a report as to the reason for non-implementation of the warrants of arrest. Stop. Next, the report of the Deputy Sheriff of Calcutta dated 7th July 2023 states that the accused has sold the property and vacated the address sometime in 2022. Stop. Next, let a copy of the report be made available to the advocate on record of the petitioner, of the award holder. Stop. List this matter on 21st July 2023. Next.
In this matter also, my lord, in this matter on 7 July, warrant has been issued against the award data number 5. Sheriff has to file the report regarding.
Same order. Should the date of the report of the Deputy Sheriff, which is 8th June 2023, and states that the warranty is not staying at the mentioned address and has left for Tamil Nadu quite some time back. Stop. Tabaraki, let a copy of the report to 21st.
Good.
128.
28 in this matter on 7 July, warrant has been issued, my lord. The sheriff to file report regarding.
Report of 30th June, Aki order, 30th June 2023. The warranty has sold his house in February 2023 and was not found in the address mentioned. Stop. Same order.
$129.
Matter also, warrant has been issued on 7 July, my lord. Sheriff to file report.
Same 30th June. The Deputy Sheriff has filed a report stating that there is no police report. Stop.
In this matter. Can you extend the returnable debt warrant, my lord, by for the period of 4 weeks or 6
Next, the warrant of arrest is accordingly extended for a further period of 4 weeks from today. Stop. List this matter on 18th August 2023.
Good.
The requisition for continuation of the warrant of arrest, the advocate on record of the petitioner shall put in the requisition for continuation of the warrant of arrest.
Good.
$130. IDFC First Bank.
Lordship, in this matter, this is my execution application, your lordship.
I'm for the award details, Your Lordship.
In this matter, your lordship,
Microphone, please.
Your lordship, in this matter, Wyden order dated 25th April 2022, the judgment debtors were directed to file their affidavit of assets, but till date that was not filed, your lordship.
Should 8th June 2023, Your Lordship, there is an order wherein Your Lordship directed them to file an affidavit disclosing evidence of the award being served on the respondent.
That is in the GA, your lordship, but today is the date fixed in the EC.
8 June is not here. Where is the order?
Okay.
That is in the GA application. They have paid for the GA application and that matter.
GA
that
for
order-
what?
That's 2 points I have taken, Your Lordship. That's one is unilateral appointment and another one, Your Lordship, this is executable under section 47. Is all awards, Your Lordship, of this.
Yes, yes, that will be considered later. Yes, when we do file the affidavit of assets?
As well as Your Lordship's.
By 21st. Where is the judgment debtor based?
All Calcutta, how would I?
Yes,
How-
it appears from records that the judgment debtor has not filed his affidavit of assets as directed by a coordinate bench on
25th April 2022.
25th April 2023.
Two, Your Lordship.
Two. Stop. List this matter. On 28th July 2023, stop. The affidavit of assets of the judgment debtor shall be made over to the advocate on record of the petitioner by 25th July 2023. Next.
In my application also, let them file an affidavit, Your Lordship, because my application needs to be heard, Your Lordship, also by the Honorable.
No, I will decide that point without affidavits. Next.
So kindly, Your Lordship.
The unilateral appointment at the stage
Unilateral
of
appointment
execution.
and
Yes, I
whether
will
it's
decide that
executable.
point. Yes.
Any day may be fixed, Your Lordship, for this.
Yes, that will be sometime in August.
Any day, Your Lordship. whatever.
The GA of the judgment debtor will be listed on 4th August 2023.
4th.
Next. 3rd August 2023. Next.
One 31 IDFC First Bank.
Lord, I was praying for, I will appear for the judgment debtors. Lord, I was praying for a week's accommodation because on the last few occasions they were here. Lord, but today, my lord, they could not be present.
Where are they from?
Salt Lake. They're not.
Yes, learned counsel appearing for the judgment debtors seeks a week's adjournment. Stop. List this matter.
I'm so sorry, my lord. I'm so sorry. So it's probably
Appearing in some
1:30.
other matter, Your Lordship.
Probably 1:32. I'm so
Yes,
sorry.
it is other matter. Your Lordship, in this matter already, the position of respondent number 2, we have already started cross-examining. He should be here today, but
yes,
no one.
Lordship, I am for the judgment debtors. Lordship, they are seriously ill, Lordship.
They, all of them.
Yes,
How
Lordship.
many judgment debtors?
Lordship, there are two judgment debtors.
Where are they based?
In Calcutta, Lordship.
Calcutta based.
When were they last examined?
Your Lordship, on 17th February 2023.
Next, 21st. Both of them
Lordship,
should be
they have
there.
been instructed to adjourn the matter, Lordship, on 1 week.
Upon costs, additional costs. All right. Yes, and I'm going to give you punitive costs for adjournment. Last examined on in February.
In February, Your Lordship.
February. Very well.
They have submitted the affidavit of assets, they have submitted as per
Costs, if they are not here on 21st. If they are here on 21st, no costs. All right.
Lordship, all liable.
Yes, none of the judgment debtors are present in court for examination. Stop. The judgment debtors were last examined in February 2023. Stop. List this matter on 21st July 2023 for both the judgment debtors to be present in court. Next.
132.
I'm so sorry, my lord. May I renew my prayer for accommodation, my lord?
The judgment debtor wants accommodation. What are you saying?
My lord, they could not be present in court today for examination. May I renew my prayer for
Lordship,
accommodation?
only one indulgence. They have not yet filed their affidavit.
I
of
will
assets
file it
too.
by next week, my lord. I will file it because on the last occasion I handed over certain orders by the NCLT where the judgment debtor number 1 there was the section 9 application was admitted against the judgment debtor number 1, but there is a stay not with regards to the insolvency process but to constitute the committee of creditors by the appellate tribunal.
Regardless of that, your affidavit of assets should be in court.
I'll file it within a week.
Yes. Learned counsel appearing for the, how many of them? 2?
But 3, my lord.
3.
Three, Your Lordship.
Learned
One is
counsel appearing for the judgment debtors seeks an adjournment. Stop. Counsel submits that the affidavits of assets of the judgment debtors will be filed by 21st July 2023. Stop. List this matter on that date.
Great.
Next.
133. Ukro
33.
Capital.
33, my lord, I am appearing on behalf of the judgment debtor, my lord.
Appearing on behalf of the award holder, Lordship, by an order dated 9th of June 2023, Lordship had recorded that they have not been appearing for the last 2 occasions, and Lordship had asked them to appear for the examination. Lordship, the judgment debtor number 1 had already started his deposition.
Judgment 2.
Judgment debtor number 2 had already started his deposition. During in his affidavit of assets as well as during the deposition, he was asked to give the list of sundry debtors that he had mentioned, details of the sundry debtors. He had mentioned certain LIC policies which has been mortgaged. He was asked to give documents supporting that they were mortgaged. Nothing had been filed
My
to
lord,
date.
today, due to his illness, my lord, he is unable to appear before your lordship, my lord.
Illness.
My lord, yes, my lord. My lord,
Where is he
one
based?
medical certificate, my
Where
lord.
is he based?
Yes, my lord. Address, my lord, Howrah.
Next week, 21st. He has to
Great.
be here.
Grateful, your lordship.
Yes, the judgment debtor is not present in court. Stop. The judgment debtor was being examined on the last occasion, which is 15 June. When was it?
17 February 2023 last.
17 February 2023. Stop. List this matter on 21st June 2023 for the judgment debtor to be present. Next.
Grateful, your lordship.
Lordship, in the meantime, let them file the documents. Which
Yes, yes. The judgment debtor will file the documents recorded in the order of.
Lordship, it's in the during the process of deposition.
Yes, recorded in the last deposition
Lordship.
by the returnable date. Next.
Grateful, your lordship.
134, Mrs. Cholamandalam.
My lord, in this matter, Mr. Shonjit Kumar Mal is appearing. My lord, I have been instructed to inform the court that there is a bereavement in his family, my lord. My lord can keep the matter any day.
Adjournment is prayed for on behalf of counsel appearing for the judgment debtor. Stop. List this matter on 21st July 2023. Next.
Grateful, my lord. Grateful.
135, SMI.
My execution application, my lord, I was examining the witness and he was supposed to, my lord, give details of the bank accounts and other, my lord, details with regard to the pledged documents of the properties. And my lord, he was also, my lord, he said that 3933 shares of Balrampur Chini Mills were also, my lord, with him, with, my lord, which we asked the receiver to take possession. But none of these has been complied with. My lord, he only came before the special officer and said now that I don't know, it has been sold by my chartered accountant. So, my lord, I will cross-examine him as to how could he give a wrong information.
Yes, where is he?
And he's not provided the documents also.
My lord, at that point of time, he was in police custody. That's why, my lord, it was not in his scope and knowledge. Thereafter, my lord, he came to know this fact, and that was.
No, no, eight to
My lord,
last order.
on the special officer, my lord, may I file my report? now?
Yes, the report of the special officer of the report of the learned special officer is taken on record. Stop. Mr. Banerjee, only for 2-3 minutes.
No, no, I cannot examine. Lordship sees my lord's last order. He has not complied with that. He was, this order was passed in the presence of his advocate and him before this court.
June.
Yes, my lord. Upon examination. this
Yes,
was
has
passed.
not produced the audited accounts.
Nothing.
Microphone, please.
My lord, what has
I can't understand. Microphone.
My lord, he has relating regarding, my lord, the shares, my lord, that was not in his custody. It was under the with the brokers, my lord, at that point of time when he was in the police custody in Madras, my lord. And thereafter, they have after returning from the court, my lord,
You were
he
here on the last day.
my lord, as on date, my lord, it is not in his custody, my lord. It has already been sold out. I have been in.
Very well. You will cross-examine him on the next day on this.
Yes, and my lord, the last paragraph has to be complied with. That also is not complied. That was also
Yes.
passed in his after questioning him.
Yes, the judgment debtor has not complied with
He
the
has come with the one, my lord.
with the directions passed in the order of 16 June 2023. Stop. The advocate on record of the judgment debtor submits that which are with the police audited accounts.
No, no. But audited accounts, he has come with the photocopy of the audited accounts, my lord. He has come with that.
Then what has he not complied with?
Yes,
Regarding
provide
shares.
that to me, my lord. I will come ready with that. I can't. my lord.
Very well. Has not complied with the directions contained in the order of 16 June 2023 to the extent of providing copies of these documents to the advocate on record of the petitioner, award holder. Stop. Let these copies be made over to the advocate on record of the award holder in the course of the day.
Grateful.
Stop list this matter on 21st or 28th,
Any day, Lordship pleases, my lord.
because too many matters, list this matter on 28th July 2023.
28, grateful. my lord.
Grateful to Lordship.
Non-commercial matter, examination of judgment debtor, item number 15, Tata Capital Financial.
My lord, I appear for the petitioner. My lord, by an order of 9 June 2023, Lordship has recorded several opportunities were given to my lord 3 and 4 judgment debtor number 3 and 4. They've not filed their affidavit of assets, and so warrant has to be issued against them. And my lord, 2nd of February 2022 also records
Just 1 minute, let me see the orders, please. Which one are you?
9 June 2023. Lordship will take the order.
Yes,
Lordship's order.
I have it.
Service কি দেখাচ্ছে দেখে নাও ওদের উপরে that repeatedly my
So
lord
this is with regard to the
3 and
judgment
4
debtor.
3 and 4 my lord. Now my lord kindly takes my lord the order.
Records, the order of 9 June is only about 4.
No, lordship comes to the last paragraph, page 2.
Yes, yes.
Now my lord, kindly, if your lordship takes my lord, there are several other orders earlier, but kindly takes the order of 17th November 2021.
Yes.
Where my lord, judgment debtor number 2 is also doing the same. He had surrendered, and then my lord again opportunity is given, and he did not also file. So warrant has to be issued again against through 3 and 4.
This is Shiba Shodhar.
Yes, my lord. Three of them, my lord. Aman Kumar Agarwal, then my lord Anant Kumar Agarwal, and my lord Shiva Shodhar.
Yes. And when did you communicate this order?
Yes, yes, my lord.
On them?
Yes, my lord.
When did you do that?
My lord, it was posted on my lord 10th of June. And my lord, first one showed item delivered addressee on 19th. And the second one shows, my lord, on 13th June, it has been delivered.
No, but to all 4?
All,
to all three?
two, my lord, because the last order is with
3,
regard to
4
4
and 2, you said.
Yes, but last order is with regard to 3 and 4, and 2, my lord, Justice Sharaf had
No,
passed.
but 2 you have not. So I will pass an order in terms of 3 and 4.
And my lord, kindly then directs, gives opportunity to 2 once more, my lord.
Yes. The order passed by this court on 9 June 2023 was delivered to the judgment debtor numbers 3 and 4 on 19th and
my lord, 13th.
On 13th and 19th June 2023. Stop. The judgment debtors have not filed their affidavits of assets till date. Stop. Despite such service, comma, stop. The order of 9 June 2023 records that similar and several opportunities were given to the judgment debtors to file their affidavits of assets. Stop. Next, no one appears for the judgment debtors. Stop. Next, the superintendent of police and the officer in charge of the local police station are hence directed to execute, to issue a warrant of arrest, to issue warrants of arrest, warrants of arrest against the judgment debtor numbers 3 and 4, and produce them in court on, what is a good date, Mr.
My lord, only
Banerjee?
thing is that, my lord, the warrants are issued by the sheriff and the registrar, my lord, and we have to give that cost to the,
Requisition.
yes, my lord.
Very well.
They only execute it, the superintendent.
Yes. Execute issue execute warrants of arrest against the judgment debtor numbers 3 and 4, and stop. The judgment debtors shall be produced in court on.
My lord, it takes around 4 weeks, my lord, for execution.
On 18th August 2023. stop the warrants of arrest will be issued by the office of the sheriff of Kolkata upon the requisition put in by the advocate on record, the petitioner, in due form. Stop.
And my lord, with regard to 2, in terms of the order of 17th November 2021, my lord, he has also not filed. So my lord, that my lord, an opportunity may be given, and thereafter, my lord, if he doesn't file, then I'll seek for a warrant
Yes,
against.
the order passed by a coordinate bench on 17 February 2023.
2021, my lord.
It says 2023.
Okay.
দেখাও তো এই order-টা।
আমারটা 2021 কেন? The Shiva Sabda report. There are 3. This is with regard to 3, my lord, the coordinate benches passed. This is, my lord, with regard to 3, my lord.
No, I asked you the name and you said yes.
No, my lord, Shiva Shaddar is respondent number 4, my lord. Shiva Shaddar is respondent, which my lord has already passed an order. My lord, the last order with regard to respondent number 2, my lord, is, my lord, sometime in, my lord, 2021 by Justice Kapoor. Sorry, 2nd of February 2022 by Justice Kapoor, my lord. So, my lord, he may be given, my lord, another opportunity to file an affidavit of assets. If not, then I'll pray for warrant against.
It appears from an order dated 2nd February 2022, passed by a coordinate bench, that the judgment debtor number 2 doesn't say anything about judgment debtor number 2, any direction, just
Yes,
says.
kindly sees, insofar as judgment debtor number 2 is concerned, it appears from the order dated 8th November 2021 that the judgment debtor number 2 had been arrested. So, my lord, arrest would be only upon warrant being issued and him not filing the affidavit of assets. My lord. Last paragraph.
That a warrant of arrest had also been issued against the judgment debtor number 2. Stop. Learned counsel with the petitioner submits that the judgment debtor number 2 has also not filed his affidavit of assets. Stop. Till date. Stop. The judgment debtor number 2 is hence directed to file his affidavit of assets within, what's a good time?
4 weeks, my lord, same time lordship gives.
Within 4 weeks from today. Stop. List this matter. The advocate on record of the petitioner shall communicate this order on the judgment debtor number 2 by 18th July 2023.
Grateful, ma'am. There is a arbitration.
Item number 16, Shrey Equipment Finance.
My execution application on the last date, my lord, I was cross-examining the judgment debtor number 1.
This matter also has an application.
Item number 11.
Yes, my lord, that application is irrespective of that, my lord, I can cross-examine because that is an application for review of a stay which has been sought for of an order passed by Justice Sharaf. So, my lord, I don't know how is it maintainable. I'll argue that when that is taken up. And my lord, I don't find any error.
Stay of an order. What is the order?
No, the order which is there in the stay application, the prayer is of an order. My lord, kindly takes the prayer in that. If my lord is, my lord, an order, the order dated, 9th of June passed by my lord in execution application will be reviewed. So, my lord, if that is a review, then my lord, I'll take the point of maintainability because in execution, my lord, I don't know where from review comes. And secondly, my lord, I don't find any error apparent on the face of the record of the order. because that is an order passed, my lord, pursuant to submissions being considered, and lordship held that the execution has to take place and he has to be examined. So, my lord, there is no question of any review, but I'll argue it if that matter is taken up. But in the execution application, she was to provide a lot of documents in terms of my lord's last order, which my lord had passed, whereby, my lord, she was directed to provide, my lord, the bank statements for the last 5 years in respect of 5 bank accounts, and also, my lord, to file a copy of the life endowment policy in terms of as stated in subparagraph C of paragraph 8. Now, my lord, these have not been complied with. This is a separate order passed in the execution.
Which order are you looking?
My lord, 16th of June 2023, upon our examination, this was being passed. This has not been complied with. So this needs to be complied with. And in the execution, my lord, she has already stated that the entirety of the issue and the working of the company was looked after by her husband. So he should be, my lord, present for examination.
Mr. Banerjee, whether I agree with you or not, that's a separate issue. But if a review has been filed, we have to argue that first.
Very well, lordship.
And let me get that order out of the way.
Yes.
And then we will proceed.
Yes, that is also appearing today in the list, my lord. It is appearing, my lord.
That is item number?
Item number 11.
11. Very well.
Milord, on the
You
eight-
argue the 11, please, Mr.
Milord, may I, Milord, before I start arguing item number 11, I'm ready otherwise.
Mike.
Milord, before I start my argument on Milord in item number 11, I just indicate one thing. Milord, I am told that my lord is hearing, Milord, a few matters where my lord is deciding, considering whether section 47 application is maintainable or not in an Milord execution proceeding arising from an arbitral award.
I've not started hearing any matters.
Oh,
No.
Wait.
I have just been made aware of these
Milord, this
applications
matter
being
falls
filed.
in the same category. Milord, I just indicate that.
Yes.
Milord, not meaning to say that, Milord, I do not want to argue it today.
No, that's fine. But I have not started hearing. I think on one day you were there,
No,
or I think
Mr.
was it
Guho
Mr.
was
Banerjee?
there, Milord. Mr. Guho, Milord, communicated
No.
this to
I
me.
remember Mr. Banerjee being here,
I
and
was not.
some other counsel arguing, just started his arguments in favor of the application. That's all.
A
Yes.
very interesting point, Milord, to develop before your lordship's go. Milord,
Section
On the review or on the application?
Section
I'm
47
sorry,
is
Milord.
decided.
On the review or the application?
Milord, this review application would, Milord, involve that point. Whether, Milord, my lord can exercise power under section 47, Milord, while Milord insisting over an execution
But the
proceeding.
order you want review of that mentions nothing about section 47.
Yes, Milord, that has something to do. So, of course, subject to correction.
So
by
you're
lordship.
saying that's a new and important matter under 47(1), order 47(1).
It's not order 47, section 47. Yes, yes. Simple.
New and important matter. Yes.
To my humble understanding. May I, Milord, please? Hear me?
Yes, your review, please. Please argue because I have to deal with that.
Yes.
And you have sought review for the order of
9th June
9 June.
2023. Milord, page 66. My lord will kindly take, Milord, the application only. But that, Milord, contains all the documents.
Page 66.
Page 66 of the application.
Yes.
হ্যাঁ মানে তাহলে একবার এটা একবার ওটা দেখতে হবে, ওটা হলে সুবিধা হবে। If my lord kindly takes, Milord, the order.
Yes.
May Milord place it, Milord, once. The submissions made on behalf of the award daters shows that the award daters do not have defense to being examined in the present execution case. The dispute which is sought to be raised at the stage of execution proceedings is that the judgment daters were not served with a copy of the award dated 16th March 2016 and came to know of such only from the execution petition. Learned counsel appearing for the award daters, Milord, I just remind your lordship, Milord, I could reach late here. Milord, I could reach when my lord had already started dictating. Milord, my learned juniors were there. Appearing for the award data submits that the award data
You want your name to be deleted from the array of parties? What is it? about?
hardly matters.
Yes.
Learned counsel appearing for the award data submits that the award data hence had the option of seeking recourse under section 34 of the act for setting aside the impugned award. Strangely enough, however, the award daters did not take any step for making an application for setting aside of the award or writing
to the learned arbitrator for a copy of the award. Even if the submissions made on behalf of the judgment debtors is taken as correct, 1 year has gone from the date on which the award debtors received a copy of the execution petition. The affidavit of assets is already on record, then Millard, the matter is made returnable. Millard, what happened on 9th of June, Millard, I am told my learned junior, Millard intended Millard to make over, Millard file a copy of an affidavit in, or it was Millard styled as affidavit in opposition, because Millard, that was the previous direction passed by the Honorable Coordinate Bench.
Affidavit in opposition
That-
to
that-
what?
To Millard, the execution
To
application.
the execution application.
To the execution application, Millard, it was Millard.
Why are you so embarrassed saying that, Mr. Banerjee?
I am embarrassed because of the nomenclature given to the affidavit. Millard, subject to Millard correction by your lordship. What I have learned is Millard,
I don't know what to correct because it's something new, that's why.
but that was what was the desire of the Honorable Coordinate Bench. If my lord kindly just have a look at page 38 once.
38.
Yes, ma'am.
Yes.
Counsel on behalf of the respondent seeks time to file his affidavit in this matter. He submits that it is unilateral appointment. That was the first point taken. And he further submits that they have not yet received the award in this matter. Let affidavits be exchanged. Affidavit in opposition be filed within 4 weeks from date, and reply thereto, if any, be filed within 2 weeks. This was the affidavit, which in adherence to the directions passed by the Honorable Court, we wanted to tender. আচ্ছা পরের লাইনটা পড়ে দিচ্ছি। The arguments made by Siddharth Sajan are vehemently disputed by Mr. Shatarup.
Thank you for placing this line. Otherwise, I wouldn't have believed that Mr. Banerjee opposed the stand.
Because on the last occasion, Lordship asked me, why didn't you oppose? I said I oppose, but that was the view of the court.
That was the desire, of the Honorable Court. That was tendered, but my lord was of the view on 9th of June that affidavit in opposition cannot be taken on board. Keeping aside the nomenclature, the affidavit was intended to be filed, to show 3 things. Principally.
Mr. Banerjee, you're now arguing for
Execution.
review of
Correct.
that order,
Correct.
9 June.
Correct.
You cannot argue your application.
I'm not arguing my application.
No, you're saying the affidavit was required to show 3 things. That is nothing to do with the order of 9 June.
That may have something to do with the order of 9 June, because my lord, while passing the order on 9th of June, was of the view that our sole point was non-service of the award. And I could have made an application to the arbitrator seeking a copy of the award. By the time,
Restrict your submissions to only the facts which have been recorded in the order of
or
9 June.
which have not been recorded. If I may use this. Because
You're making it easier for the court to dismiss the application, Mr. Banerjee. You keep it under 47(1), it will be more difficult for me then to deal with it.
I
So
am
I would
trying
like
to-
to go the difficult
I'm
path.
trying to take your lordship.
rather than the
to
easier part.
I'm trying to take your lordship to section 47. Before I cross the hurdle of order 47. An order, maybe, there may be errors apparent on the face of the record if there is an erroneous, recording on fact, in mistaken recording, of fact, or, if there is, something which is not, recorded. Omission to record, a material fact may also, be an error apparent on
What
the
is a
face of the
material
record. The material fact was that was the arbitrator, had passed away prior to, service of this execution application upon me. Mr. Dash, Mr. Pulin Bihari Dash was the learned arbitrator.
Yes.
And he passed it. So my lord was of the view why I did not make an application, after getting the execution application. Why did I not make a request to him, seeking a copy of the award, which I could not do because of these facts. That is what has not.
So a fact, you can come within order 47(1), even that is arguable. If a fact has been placed before the court and the court decides not to record it.
Correct.
In this case, this is the first time you're placing that fact before the court.
This was submitted by me. I came late. My lord was had started dictating the order. I interrupted, which I do not know whether I should have done or not. But this I indicated. This I can take responsibility of saying this.
Very well. So there are three things under which you can come under 47(1). Which is the
Milord, errors, Milord, apparent on the face of the record, Milord, in a sense that, Milord, this was not, Milord, what passed through my lord's mind, possibly that, Milord, the arbitrator was no more there. I could not have made, Milord, an request to him, Milord, to the
no,
deceased.
the recording in the order is, Mr. Banerjee, that nothing to do with the arbitrator or whatever, that even after you got the execution petition, 1 year has passed.
Correct. Milord, there.
And you became aware of the award,
Correct.
taking your case
Correct.
from the execution petition.
Absolutely.
1 year has passed and you have not filed a 34.
Kindly, Milord, have a look at section 36 once.
36 of the?
Of, Milord, the arbitration and conciliation.
Yes.
Kindly, Milord, my lord has gone through this, Milord, a trillion times. Milord, may I just please once more. Milord, the opening words of, Milord, subsection 1.
Yes.
Where the time for making an application to set aside the arbitral award under section 34 has expired, then Milord, subject to provisions, etc., Milord, this should be executed or implemented. So, Milord, the mandatory precondition, Milord, to file an execution application is, Milord, this time, Milord, to file an application to set aside the arbitral award, Milord, must have expired. Then only, Milord, 36 application would lie.
Yes.
Now, if my lord kindly comes to, Milord, section 31. Kindly take section 34, then, Milord, kindly.
No, a signed copy of the award is
I'm
31.5.
not on that. 31.5 is not on the signed copy. It says, Milord, the arbitrator, Milord, the takeout treaty and all those decisions of the Honorable Supreme Court, Milord, Venadas takeout treaty, says that, Milord, this award is to be served personally by the arbitrator to the, Milord, arbitrator. Any other service is not, Milord, what is contemplated under section 31.5. Milord, kindly take section 34.
No, but 31.5 says after the arbitral award is made,
Yes.
a signed copy shall be delivered to each
Correct.
party.
Correct. Milord,
Where
that-
does it say that the arbitrator will do it?
Milord, that is, Milord, then explained, Milord, by the Honorable Supreme Court.
That 31.5 means the arbitrator must give.
Yes.
Takeout treaty is Justice Banerjee.
No, Supreme Court, Milord, if I'm not wrong.
No, takeout treaty was followed by Justice Banerjee in some other,
Milord, my lack of knowledge,
in
Milord,
some
I
other
could not-
decision,
I could not claim.
relying on takeout treaty.
Takeout treaty is possibly, Milord, the parent judgment. Milord, my learned senior friend is more, Milord, acquainted with that branch of law.
So there is a judgment dealing with all this, my lord, by our division bench. My lord, this was a point taken. This was a point taken, my lord, by several, my lord, judgment debtors years back. And around 1,000 matters, my lord, went up to the Chief Justice of this court in the division bench. It was heard at length. And it's been decided, considering, my lord, the General Clauses Act, Section 3 of the Arbitration and Conciliation Act, and, my lord, Section 31, that, my lord, the arbitrator under the Arbitration Act, my lord, the arbitrator needs to, my lord, serve on him at the last known address by proper apostle, my lord, of the postal receipt and acknowledgement. And, my lord, once it is posted, it is deemed to be under Order 5, Rule 9, read with Section, my lord, 3, my lord, I believe, of the General Clauses Act, that it is deemed to be served on him or her upon the expiry of 1 month. And, my lord, all these matters thereafter were remanded back and execution continued, because prior to that, all the execution applications were stayed on this ground. So this issue is decided. I can give the judgment to my learned friend, and my learned friend can take it.
No
Yes,
court.
it's retired. It's decided, my lord, in 2018, 1 CHN, Calcutta 391. This was a judgment passed by the division bench of Justice Nishisha Matre. At which this is decided. This issue is all decided. So once I show that there is a postal receipt, I will only have to calculate 1 month from that, and it is taken to be deemed served upon him. And his time for Section 34 starts from the expiry of 1 month, my lord. This issue is decided.
No quarrel with this proposition. Milord, in the execution application, in the affidavit, Milord, accompanying, Milord, this execution application in the tabular form, Milord, there are 2 postal receipts annexed. Milord, suggesting that, Milord, under those postal receipts, Milord, this award was delivered to us. Milord, we have taken a specific stand that there were multiple arbitrations, Milord, against us before the same arbitrator, where the claimant was also the same. And, Milord, under those postal receipts, the envelopes, Milord, with those postal receipts, Milord, separate article altogether were served on us. That is what was my case. And my lord, on the above, my lord, at the top of it, my lord, my specific case before your lordship was also this, that my lord, the appointment was unilateral and that's an admitted position of fact. My lord, I can demonstrate from the execution application itself, which has also possibly, my lord, not gone down, my lord, in the order passed on 9th of June. My lord, if the appointment is unilateral because of the development of law now, my lord, this entire reference is bad in law, as if, my lord, this was honest. And if I can satisfy my lord's concerns that because of this admitted unilateral appointment.
No, Mr. Banerjee, don't go on to the Arbitration Act. Come to Order 47-1 for a review
Yes.
of the order. Only 47-1, the three preconditions you have to fulfill.
There is a fourth one also.
Yes.
Which says, my lord, sufficient other reasons.
Yes, or any other sufficient reason.
Yes.
That's right. Yes.
And my lord, that is also explained. Dada, তোমার এখন CPC বানাবে। ও CPC টাইপ বানাবে। My lord, handle. My lord, I'm thankful to my lord.
No, I have it. CPC. I have it.
And my lord, there is an interplay of section 47 and order 47 in my matter. My lord, that's my lord, my humble understanding of my application.
Yes.
Any person considering himself aggrieved by etc. and who from the discovery of new and important matter on evidence, which after the exercise of due diligence was not within his knowledge or could not be produced by him at the time when the decree was passed or order made, or on account of some mistake or error, may the first criteria, my lord, I do not satisfy. Or on account of some mistake or error apparent on the face of the record, or for any other sufficient reason desires to obtain. So, my lord, these are, my lord, the criteria. My lord, discovery of new document which I could not discover despite due diligence. Second, my lord, mistake or apparent error apparent on the face of the record, which, my lord, includes error of law and error of fact both. And my lord, this is not only error but also mistake. My lord, mistake means, my lord, includes omission also, my lord, to take note of certain facts which are otherwise there on board. And my lord, I say that, my lord, the mistake, my lord, crept into, my lord, unknowingly, because, my lord, there were, my lord, documents, averments on board to show that, my lord, the appointment was unilateral. And if the appointment is unilateral, my lord, the award is a nullity. And if the award is a nullity, I mean, it's a duty of, my lord, the executing court, my lord, to my, again, humble understanding, my lord, not to proceed with the execution process. And, my lord, there, my lord, the executing court, my lord.
So this is disregarding the
Service-
prescribed statutory route under the 1996 Act.
I'm not
But you don't need to file a 34, you don't need to go through the 34 route at all. You can just come at the stage of execution
Can you
and
see,
say,
my lord, the grounds of section 34? My lord, section
Mr. Banerjee, I will dismiss the review application at best, and I will, of course, with reasons. I'm telling you what I will do,
yes, ma'am.
because I will dismiss the review, and at best, not at best, I will fix the application for hearing on a certain date. But the examination will go on.
My lord, I'm not standing in the way of the examination. Unless I get a stay order, my lord, I cannot stand in the way, which is why, my lord, I have ensured that the documents, my lord, which my learned friend was referring to, my lord, are all, my lord, carried today. Those have been carried today. The witness is here. I'm not standing in the way of examination at all. Unless I, my lord, can satisfy my lord's conscience that, my lord, the execution proceeding cannot continue, my lord, I cannot stop the execution.
Very well. Mr. Banerjee, your response please to the
My
47.
lord, the entire submissions made do not stand on any ground at all because the law is well settled. My lord, kindly takes the award once. This, my lord, every time they come up with this issue of, my lord, unilateral
No,
appointment.
on the review, on the
My lord,
review.
my learned friend has
Only
not
on the review. I will have to decide that first.
review, my lord. My learned friend has not argued at all as to why, my lord, the order, there is any apparent error on the face of the record. No arguments made. He is arguing on merits, which also, my lord, in 2 minutes time can be, my lord, demolished. My lord, kindly takes the execution application, page 12. Reference has been, my lord, made in 2013. The Supreme Court has decided this issue, my lord, of reference made prior to amendment, my lord. Unilateral amendment will not apply. It's decided now.
Award may come after in 2016, but it has been distinguished what is court proceedings and what is arbitration proceedings. So, my lord, a reference made prior to the amendment, it does not have a retrospective effect, it will have a prospective effect. Reference made on 21st of May 2013. This argument is, my lord, baseless.
Very well. Let me pass the order on
Yes, my
the
lord.
review and then you can
Yes.
carry on, because I have to get that order out of the way
Yes, my
first.
lord.
And it's in fairness to Mr. Banerjee's client because he has preferred a review. Yes,
My lord is deciding on my review application.
yes, yes.
Then, my lord, may I place, my lord, certain decisions? My lord, may I trouble your lordship, or if my lord kindly allows me to come back any other day, kindly, my lord, allow me, my lord, to make certain submissions, my lord, for, my lord, at least 10-15 minutes.
But you have made the application. Why are you not ready today, Mr.
My lord, I'm
Banerjee?
ready today. My lord, I can here and now place those decisions.
Yes, yes. Place the
I'm
decision.
sorry, my lord, I am troubling your lordship.
And on what point, Mr. Banerjee?
My lord, firstly, that, my lord, this inter proceeding was a nullity.
No,
Because
no, no. Mr. Banerjee, no. That is your application, merits of the
that's
application.
not on the merits of the application.
Mr. Banerjee, then let me pass the order. You challenge my order. Any other decisions you want to place?
My lord, I wanted to show that, my lord, if the appointment is unilateral and which is apparent from the records already made available to the
No,
court.
that
my
is
lord,
all on the
one.
merits of the application.
And my lord, service of
If you want to cite any judgment on the review, section 40, order 47-1, you're most welcome to.
order 47-1, my lord, I am not.
Very well. The judgment debtor, one judgment debtor,
There are two.
the judgment debtors have filed an application for review of the order passed by this court on 9th June 2023 in execution case number 212 of 2022. Stop. The other prayer is that all further proceedings in the execution case be stayed till disposal of the application for review. Stop. Next, the order under review record that the judgment debtors have raised a dispute at the stage of the execution proceedings to the effect that the judgment debtors were not served with a copy of the award dated 16th March 2016 and came to know of the award only from the execution petition. Stop. The order, apart from noting the submissions of learned counsel appearing for the parties, comma, the order further records that the judgment debtors, comma, for some inexplicable reason, comma, did not apply for setting aside of the award, including by writing to the arbitrator for a copy of the award. Stop. The fact of the judgment debtors not taking any steps for setting aside of the award despite receiving the execution petition more than 1 year from the date of the order, i.e. 9 June 2023, was further recorded. Stop. The matter was hence, the execution petition was hence listed for 16 June 2023 for examination of the judgment debtor number 1. Stop. Next, the application for review. The application accompanied by the memorandum of review was filed on. When did you file it?
10th of this month, my lord, I am told.
10th of July, 2023. Stop. Next. Learned counsel appearing for the petitioner as well as the judgment debtor as well as the decree, the award holder have made their respective submissions. Stop. According to counsel appearing for the judgment debtor slash debtors slash applicants, comma, the order under review suffers from an error apparent on the face of the record, since the order omits to mention that the arbitrator, what, died when?
It is not known to us, but much before, my lord, service of the execution application and, my lord, omission to take note of the unilateral appointment.
No. Before
Date, my lord, before service of the execution application.
that the arbitrator passed away much before service of the execution petition on the judgment debtors. Stop. The other point is of the unilateral appointment of the arbitrator, which according to counsel renders the award a nullity. Stop. Next. The point of unilateral appointment and the consequence of such are the the substance of the application filed by the judgment debtors, namely GA1 of 2023, where the judgment debtors have GA1 ta dato. GA1. What is the application number which you have filed?
This is GA number 1, my lord, in RVW number 35.
No. Where have you challenged the appointment, unilateral appointment? This GA?
My lord, in this GA, my lord, I have said so, my lord, in so many words. My lord, I'll just indicate.
No. So you have not filed a separate application?
No.
Ki bola? Now, substance of the judgment debtors' objections to continuation of the execution case. Stop. Surprisingly enough, comma, none of these contentions form the subject matter of an independent application filed by the judgment debtors. Stop. All these contentions have now sought to be raised in the application for review of the order dated 9th June 2023. Stop. The reason for not filing a separate and independent application to bring these, to seek the relief of a declaration of the award being rendered null and void for the reasons argued, comma, if that option is at all available to the judgment debtors at this stage of the proceedings, comma, appears to be clear, seems to be clear. Stop. The judgment debtors perhaps know fully well that the objection to unilateral appointment of an arbitrator may not be available to them at the stage of execution of an award. Stop. The Arbitration and Conciliation Act, 1996, charts out, CHARTS, charts out a route, ROUTE, for an aggrieved award debtor both under sections 34 and 37, within brackets, subject to the limitations, subject to the limited instances, close brackets, for arguing these points. Stop. The judgment debtors have not availed any of the routes provided under the statute and have raised these objections at the stage of the execution proceedings. Stop. The merits of the matter, the merits of the argument with regard to unilateral appointment will at best be considered by the court at a later stage, comma, if at all, comma, but certainly not at the stage of review of the order dated 9th June 2023. Stop. Next, the review must be confined to the grounds provided under Order 47, within brackets 1, of the capital, the Code of Civil Procedure, comma, 1908. Stop. The counsel appearing for the applicant submits that the case would come under the ground of error apparent on the face of the record. Stop. The other grounds provided under Order 47, Rule 1 may not be attracted to this case. Stop. Next. The ground of error apparent on the face of the record must be in the nature, must be an error which is stark, S-T-A-R-K, stark, and obvious to a court without further inquiry. Stop. The error must not be such that the court is led to a protracted inquiry or a fact-finding mission to locate the error. Stop. The court must, comma, at first blush, comma, be convinced that the order, that an error, that the order contains an error clear and unequivocal on the face of the order. Stop. The omission to record that the arbitrator passed away long before the service of the award on the judgment debtors does not fit within a common sense understanding or even the settled position of law with regard to an error apparent on the face of the record. Stop. Next. The first, comma, the fact of the arbitrator's passing away was, can I say mumbled by counsel? That's exactly what you did. So I will use the word mumbled. Was pointed out by counsel appearing for the judgment debtors when the court had already started dictating the order. Stop. Second, comma, the fact of the arbitrator's passing away before service of the award.
No, service of the execution.
Before service of the execution case would not even be a material fact, since the judgment debtors failed to seek recourse against the impugned award, award under section 34 of the Act, even after passing of 1 year from the date of service of the execution case on the judgment debtors. Stop. Heard, comma. There is nothing on record to show that the judgment debtors were prevented from seeking the statutory remedies available to the judgment debtors under the 1996 Act by reason of the passing away of the arbitrator. Stop. Next. Although Order 47 within brackets 1 provides for any other sufficient reason, what is the words? Reason or cause or something? Yes, any other sufficient reason for seeking review of an order / judgment, comma, this court finds no other reason to be sufficient, comma, credible or tenable in the facts brought before the court. Stop. Next. GA1 of 2023 is accordingly dismissed for the above reasons. Yes, RVWO of 35 of 2023 is also dismissed for the same reason. When will you? Yes.
EC, my lord, he has to comply with the last portion of my lord's last order, and Mr. Hansraj Jaiswal has to be present on the next day.
Next, the examination of the judgment debtors will continue. When?
Whenever he is there, my lord.
Is he here in court today?
She is here,
No, I had said on the last occasion that I will not proceed with her. She has given an answer of with regard to Mr. Hansraj Jaiswal, who has affirmed the affidavit of assets. Second affidavit of assets.
She was supposed to, furnish certain documents. She is carrying those documents. Any day that is convenient to your lordship,
And where does she stay?
In Kolkata, my lord.
In
Diamond
Kolkata.
Harbour Road.
Diamond Harbour. No, I don't want people to just come to court, wait and then go back. Yes, give me a date, please, Mr. Banerjee.
What is Shukravata Bharti?
Any date, my lord, except 21st. 28th.
Yes, list this matter on 28th July 2023, as prayed for continuing the examination of the judgment debtor.
My lord, judgment debtor, Hansraj Jaiswal. Otherwise, she will again come and she'll wait. My lord, I don't want.
Judgment debtor, Hansraj.
Hansraj Jaiswal.
Hansraj Jaiswal.
May the examination of the other judgment debtor then be closed.
Yes.
Yes, so the examination of the other judgment debtors is closed.
Great.
So only thing, my lord, her deposition that she'll provide the documents which is recorded in the.
Hansraj is a lady.
No, my lord, the lady who was in the box, Rachna Jaiswal, she has to, my lord, provide those documents, my lord, which may be given to us.
Yes, the deponent on will produce the documents, comma, as undertaken on the last occasion, comma, on the return.
The copies I have delivered.
Grateful.
Grateful.
Next.
Item number 1, Kotak Mahindra Bank.
Lordship, this is my execution application. The matter has, the judgment debtor is not traceable in this matter. I wish to withdraw with liberty to file afresh.
Not traceable?
Not
When did you realize that?
Lordship, when Lordship had given a direction for substituted service, I had informed the clients. They had gone to the last known address, but there is no one.
Where is that?
Lordship, 9th June 2020.
Where is that? Where?
Lordship, it's Uttar Pradesh, Kanpur Nagar, Uttar Pradesh.
Kanpur Nagar.
It's Bada Kanpur Nagar, Uttar Pradesh.
Yes, the advocate on record of the award holder seeks to withdraw the execution case on the ground that the judgment debtors could not be located. Stop. Did you make the substitute service or not?
It has not been made, Lordship.
It is submitted that the leave for substituted service was not, that it is submitted that the award holder did not opt for substituted service, comma, leave for which was given by the order dated 9 June 2023. Stop. Next. EC 182 of 2021 is dismissed as withdrawn with liberty to file afresh. Next.
Item number 2, Kotak Mahindra Bank.
Lordship, in this matter also, the judgment debtors are not traceable. Lordship, there was a last direction for them to file their affidavit of assets, which we had served. That also came back as addressee left without instructions. So we wish to withdraw it with liberty to file afresh.
Yes, the advocate on record of the petitioner / award holder seeks to withdraw the execution case on the ground that the judgment debtors could not be traced. Stop. Next, EC 217 of 2021 is according dismissed as withdrawn with liberty to file afresh. Any interim orders, warrants of arrest?
No, Lordship.
Are you sure?
Yes, Lordship. There was only affidavit of assets.
Yes,
direction.
due to the interim orders, if any, shall stand vacant. Next.
Item number 3, Kotak Mahindra Bank.
Lordship, in this matter, the matter has been settled between the parties. That's why I wish to withdraw this matter.
Are you breathing a sigh of relief? Yes, the advocate on record of the award holder submits that the parties have settled the matter. You're for the respondent.
No.
That the parties have settled the matter out of court. Stop. The advocate on record hence seeks to withdraw the execution case. Stop. Next, EC 220 2021 is accordingly dismissed as withdrawn. Interim orders, if any, shall stand vacated.
Lordship.
Item number 4, Messrs. Oscorp Industries.
Service is not complete upon the respondent. My lord. Kindly takes it up.
Service of what?
Lord, service of this application. This is section
Application under?
11, Section 11 of the Arbitration and Conciliation Act.
You're the advocate on record.
Yes.
The advocate on record, the petitioner submits that service is not complete. Stop. List this matter when?
But after week, next Friday. My lord.
List this matter on 28 July 2023. Next.
Great.
Item number 5, Mohammed Farad.
My lord, in this, this matter came
My
up
lord,
yesterday. Your lordship had directed me to take instructions as to whether there was any.
I'm praying for passovers or password land.
There's no can't pass over because I'm going to take up my appellate side. Yes.
The lordship asked me to take direct instructions as to whether there was any waiver as to the operability of the section 12(5).
Yes.
I have taken specific instructions from the client. He said that there has been no waiver, no agreement has been, no agreement to that effect, or no waiver has been signed ever since the dispute has arisen.
Yes, learned counsel agreeing with the petitioner submits on instructions that the petitioner did not waive the applicability of section 12 within brackets 5 of the 1996 Act. Stop. When do you want to come back?
My lord, any day.
List this matter on 18th July 2023. Next.
6, Rashmi Metallics.
I appear for the petitioner, my lord. But my lord had kept this matter today, my lord. They were for
Yes,
them to obtain instructions regard to the remuneration, my lord, of the reconstituted.
Yes. Yes.
Lordship, I have taken instruction and for the respondent number 1, Lordship, they are at least ready to pay 50,000 to all the 50 to all 3 arbitrators.
50,000?
To each of the arbitrators.
Not one time, I hope.
No. Per sitting.
But in that case, 51,000 would be better, my lord, because there are 3 parties. So there will be equal distribution, my lord.
51?
Yes, my lord, 17,000 each, my lord, equal distribution.
Lordship, it is not like, yes, 50% to be paid by the claimant and 50 by two of the respondents.
It amounts to 3 only, man. Has to be shared equally between the.
So it should be shared between the claimant and the respondent. Petitioner and the
So you're
respondent.
saying 25, you will pay 25 per arbitrator, per sitting.
Lordship, out of 50, 20 will paid by the petitioner and 25 to be shared by the two of the respondents. That is the way it has been conducted throughout.
Very well. So if I say 50%, if I agree to 50%, then how much will you pay?
25% and rest 25% to be paid by the respondent number 2.
And how much will the petitioner pay?
50%.
Out of 50,000, how much will you pay?
12,500 and rest 12,500 to be paid by the respondent number 2 and 25,000 to be paid by the
That is
petitioner.
agreed.
That was the arrangement, man.
Yes.
That was it.
You can pay more. Who are you? West Bengal Mineral
You're
Development, you will certainly pay more.
So Industrial Development Corporation and the Mineral Development. They
Yes,
are the
12,000 per arbitrator per sitting, nothing. Absolutely nothing.
50,000 is the total remuneration, out of which 50% to be paid by.
I will increase that. That's what I'm telling you.
It is, I have leave it to the
12,000, it's nothing, it's peanuts. Yes, Learned Counsel appearing for the respond number 1.
Yes.
Respond number 1 submits on instructions that the respondents are agreeable to paying.
Lordship, may I just request, Lordship, kindly do not record that. Lordship, let it be order of the court. Lordship, kindly fix the remuneration. Do not record.
Yes, after hearing Learned Counsel appearing for the petitioner and the respondents, this court is of the view that each of the arbitrators in the 3-member tribunal should be paid rupees 70,000 per sitting, and which is to be divided by the parties in the manner agreed upon by way of an order. How did you agree that? Agree to that?
That was by way of an order, man, the initial order.
By way of an order first passed in the arbitration proceedings. Stop. This figure has been arrived at after considering the submissions made on behalf of the respondents. Stop. This court is of the view that the amount suggested, the amount which was suggested is too nominal. Stop. Hence the order fixing the remuneration as stated above. Stop. Next, AP 435 of 2023 is accordingly disposed of in terms of the above. Yes. The tribunal shall be reconstituted. What do you want? Do you want judges, lawyers? What do you want?
I wanted that because the petitioner, most of the learned advocates, either they have conducted on behalf of because most of them have refused to act as the
Very well.
arbitrator.
So you
That's
want
why I wanted that retired district judge or any other retired judge of this Hon'ble court.
But we leave it to your lordship, man.
Yes, the reconstituted tribunal is appointed as follows. Now, the arbitrators of the reconstituted tribunal shall be blank and blank. Stop. The presiding arbitrator shall be blank. Next, AP 435 of 2023 is disposed of in terms of the.
Grateful.
Item number 7.
Well, I'm
Say
appealing,
engineering.
well, I'm appealing for the petition. Well, this is a section 29A application. My learned friend, senior friend is appearing in the matter. The mandate has expired on 4th of July. And this is
No, that is not correct. My lord,
From the perusal of the petition, my lord, mandate, my lord, expired a year back, June 2022. My lord, I've just recently received the brief. I'll have to take further instructions.
June 2022.
Yes,
My lord,
because
my lord,
para,
that is
my
a,
lord, kindly see.
that is a typographical error, my lord. My lord, my lord,
Typographical error, where? Yeah, the filing date is also typographical error. Yes.
We'll take para 16
Yes.
of the petition, which is at page 8. Parties mutually consented to extension of the period for making the award and extended to conclude the arbitral proceeding for a further period of 6 months at the 18th meeting held on 8th November 21. So, my lord, 6 months, my lord.
And
starts-
annexure E is where?
Yes, annexure E, my lord.
page number 24.
24, my lord. 8th November. And pleadings were completed, my lord, on 7th November 2019.
So from 8th November 2021 to 6 months thereon, why are you saying 8 July or whatever date you said?
My
4th
lord,
July.
my lord, kindly comes to page number 26, my lord.
Yes.
My lord, second paragraph, my lord, the learned advocates for both the parties submit that the mandate of this tribunal is expected to expire on or around 4th July 2023. Therefore, my lord, it was already submitted before the learned arbitrator that the mandate is going to expire on or around 4th July 2023.
So how do you reconcile this with what with the last order which was shown
My lord,
at page 24?
My lord, kindly comes to page number 22, my lord, where in the sitting, my lord, 9th sitting on 27th April 2021, my lord. My lord, the respondents had at that point of time said that the mandate of the arbitration is expiring, my lord. My lord, it was placed before the tribunal at that point of time, my lord. Kindly takes paragraph
It's not
number
a
2.
matter, 29A is not a matter of what the council are saying or what the arbitrator is saying.
Well,
It's just a mathematical calculation under 29A 1, 3 and 4. That's all.
my lord.
Then if you're not ready, come back on Monday. All right.
My lord.
Take Ms. De Banerjee also. Understood?
Yes, ma'am.
Come back. The parties need to get ready and take instructions. Stop. A learned counsel appearing for the parties need to get ready and take instructions. Stop. List this matter on 17 July 2020.
My lord, kindly
Deep
my lord,
privilege.
take it on Wednesday, my lord, I might take some more.
19 July 2023.
Deeply
That's grateful. Next.
Item number 18, Pecan Software. 8. Pecan Software.
May it please, your lordship. I have read the petition. Notes, my application, Lord, under section 11 for appointment of an arbitrator.
Mr. Rai, you have to hurry up because my appellate side I take from 3 o'clock. All right. How much time will you take?
Lord, I had indicated, Lord, on the last occasion, Lord, there is an opposition by them. Lord,
Yes.
although, my Lord, there is an agreed arbitration clause. My Lord, we had made a request, Lord, under section 21, to which they replied by saying, Lord, it's WBSCDCL, West Bengal Electricity
Yes, yes.
Distribution Company, my Lord. They said that we have a high-powered committee. You approach that. My Lord, no procedure was indicated to us as
Yes,
to how
yes,
we do
yes. I
approach.
remember.
My Lord,
Yes, Mr. Chakraborty. Any further submissions on that?
My lord, we have twofold submission. I have twofold submission. First is that, my lord, that they have approached. My lord, first is that they filed the server section 21 application notice to us. Subsequently, we say that resolving this dispute, we have formulated a high power committee. They submitted to the jurisdiction of the high power committee. That high power committee has arrived at a decision. My lord, so I will be pressing on the point of estoppel.
No. So what has the high powered committee
It has
decided?
it has rejected its demand on the pretext of, my lord, a resolution or a policy decision of the government.
No,
But-
rejected what demand? What is
My
the
lord, they
demand?
were seeking, my lord, they were seeking refund or
No,
disburse?
no, on the 21 point, section 21 notice, didn't Mr. Rice client send you?
First they send a 21 notice. There are
Yes.
221 notices. First, on the first instance, when they send us those 21 notices, we replied to them and stated that there is a high power.
Very well. So what did the high power committee decide with regard to the 21 notice?
That was not dealt with.
Not decided. Very well.
And second is that, my
Makes it
lord,
easier. Yes.
and
next.
second is that, my lord, I will rely upon section 56 of the Contract Act to substantiate that this alleged dispute which has arisen was beyond our control. It is a policy decision of
Mr.
my lord.
Chakravarti, don't tell me that I have to tell you
My lord,
that these disputes are exactly within the domain of the arbitrator,
My lord,
arbitrators.
my lord.
Let the arbitrator decide this dispute. It's
My
as
lord
simple
may
as that.
consider if that if they have submitted the jurisdiction, what I'm trying to say, if
High power committee didn't even decide on the 21.
Yes.
Absolutely not. You come
that
back
is
on,
not, but the
you come back on Monday, I will dictate the order in court.
Tuesday, my lord, instead of
Tuesday. Yes,
Subject
just
to
give me the facts. I will dictate it on Tuesday in court.
my lord.
Yes, list this matter, learned counsel appearing for the respondent, WBSCDCL, submits that the high-powered committee of what? Same,
WBSC.
of the respondent has come to a decision essentially rejecting the petitioner's claim for
Not for reimbursement.
reimbursement of GST. Stop counsel submits that the high-powered committee has, however, not come to any decision with regard to the notices issued by the petitioner under section 21 of the 1996 Act. Stop. Next list this matter on 18th, you said?
Lord, 18th.
18th July 2023 as paid for. Just give me in one page the facts and the where to
My lord.
find them. That's all.
My lord.
Next, yes, appellate side, please.
The next matter, item number 9, my lord, it's on Monday, we can be on Tuesday, my lord. Next matter.
Come here on Monday or let somebody mention and then I shall put it. Yes, appellate side.
Item number 1.
My lord, I appear on behalf of the petitioner. My lord, willful violation of your lordship's order dated 23rd November
Yes.
2022. My lord, the order is at page 112. My lord, your lordship had directed, my lord, disbursement of a sum of rupees.
First time?
No, your lordship, this is coming up for the second time.
Yes.
My lord, they had filed an appeal. My lord, we had indicated on the last day. Your lordship was of the opinion, if they can get a stay by today, my lord, then my lord.
The appeal is pending.
My lord, it is pending. It had appeared, my lord. We appeared, but the appellant did not appear. Lord, may I hand up a copy of the order? There was no representation from the state.
My lord, Mr. Rajiv Mukherjee is appearing for alleged contempt of Bhattacharya municipality. He is admitted in hospital due to urine infection, and this is the prescription.
Please, I don't want to see the prescription. What will I do with the prescription?
Kindly adjourn today's proceeding, lordship, and fix a date.
You can give the prescription to Mr. Chaudhary. Yes,
No, it's. That's why perhaps they didn't come when the appeal was called on.
very well. Although adjournment had been taken on the last occasion by the alleged contemnor on the
Oh, I'm sorry,
ground.
appeal is by the state. My learned friend is for the municipality.
Yes, yes.
So she hasn't filed an appeal.
On the ground of the state, on the ground of pendency of an appeal filed by the state, comma, the order passed by the division bench on 6 July 2023 shows that the appellants / state were not represented. Stop. The matter was adjourned on that basis till 20th July 2023. Stop. Next, the alleged contemnors in the present case is not the state, but the Bhattacharya municipality. Stop. Adjournment is prayed for who?
Adjournment is
The council, the council or the councillor? Who?
Council, learned council of Bhattacharya municipality is too much ill lordship and admitting
Hospital.
Adjournment is prayed on behalf of counsel appearing for the alleged contemnors on medical grounds. Stop. List this matter. I'm putting it on 21st, all right? List this matter on 21st July 2023.
Okay,
Mr. Chaudhary, please tell her it will be on 21st.
I'll tell her, Milord, I'll tell her I'll oppose, I'll press. I don't think it will make any difference. But I'll tell her.
Lordship. Yes.
But the
I can't hear you. Microphone, please.
Lord, I beg to appear on behalf of the petitioner. Lord, this matter, Lord, the against the Lord, the order, Lord, the judgment delivered on 19 December 2023 by your Lordship, page 14. Lord, challenging Lord the banning order, Mr. Dotto, Lord, my senior Lord, argued before your Lordship, challenging the banning order for 3 years.
Very well. It's first time.
No, not first time, Lord. Your Lordship kindly see, your Lordship directed us to serve notice because he mentioned on 27th of February and serve the notice upon the alleged contemners and file affidavit of service. Lord, we have already served.
No, is this contempt coming up for the first time?
No, contempt application appeared before your Lordship and mentioned, yes, first time. And Lord, your Lordship is directed to serve. Lord, the affidavit of your Lordship kindly see. But I have, and Lord, not only that.
The alleged contemnors are already on service. Stop. Yes.
Your Lordship, I appear on behalf of the respondents led by Mr. Syed Nurul Arifin, Your Lordship. Your Lordship, he's on legs. Your Lordship, before courtroom number 16, Your Lordship.
This matter is on 21st July 2023 as a last chance to the alleged contemnors. Next.
Deeply pledged.
I'm deeply obliged to Lord. The affidavit of service we kept on record.
The affidavit service kept on record. Next.
Affidavit of service.
Item number 3.
I'm for the petition, the first time.
Yes. Yes.
My Lordship's order is, my Lord, at page 17, 15 December, my Lord, a very small issue was there, my Lord. They had to, my Lord, give a hearing and pass a reason order, my Lord, to issue, my Lord, no due certificate. My Lord, this when the writ petition was moved, my Lord.
Very well. The contempt arises out of an order passed by this court on 15 December 2022. List this matter when?
2 weeks.
List this matter on
28th, my Lord.
4th August 2023. Service in the meantime. Next.
Item number 4. Item number 4.
For the petitioner led by Mr. Sarwaj Jahan. This matter was passed by your Lordship order dated 28th of June.
First time?
Yes, my Lord, first time. Order was not been complied, my Lord, by the contempt.
Where is the order?
Page 19, my Lord, of the contempt application.
19?
Yes, my Lord.
There's no order doesn't start at 19.
This is the penultimate portion, my Lord, I would like to.
Yes, learned counsel appearing for the petitioner needs to get ready in the matter.
My Lord, I'm
And, absolutely not. You don't even know where the order starts from. List this matter
18 start from
on
18, my Lord.
21st July 2023. Next. Next.
Item number 5.
The contempt application, my Lord, first time appearing, my Lord. Order passed on 20th February 2023, page number 20. My Lord.
Yes.
Directed to pay the amount within the
Where, from which page does the order start?
page number 20.
20. First time?
First time.
The contempt arises out of an order passed by this court on 20th February 2023. Stop. When do you want to come back?
It's 24th, my Lord, it is, State
24th.
Bank of
It has to be a Friday.
any day, my Lord, your Lordship.
List this matter on
Yes, yes.
28th July 2023. Service in the meantime.
Mashallah. 28, my Lord, 28 of some.
Yes.
The
Tell me.
28th, my Lord, I both my native village. My Lord.
4th August. As straightforward.